Good morning, good morning, good morning. It's Tuesday. It's March 18th. I can't believe it. And today we are back in court for the Commonwealth of Massachusetts versus Karen Read. There's a lot more hearings on the docket today. So we're going to be going through those hearings in whatever order the court wants to go through them. There are hearings that were left over. There were a ton of motions in limine filed last week. So the court is going to be working through all of those today and tomorrow. I expect we're going to have two incredibly full court days as they do oral argument on the motions in limine. Some of them they might not do oral argument on. I think some of the motions in limine are pretty pro forma and they will just agree on. I've got the docket pulled up, so if there's some of them that they just say, yes, docket 519 or whatever, we'll pull them up and talk about them when we get to a break. But I expect it'll be a full day today and a full day tomorrow, because these are really the last substantive hearings. I have fuzz, just it's happening. These are the last substantive hearings before trial. These motions in limine, the point of them is to settle a lot of the evidence and what will be talked about in trial before trial begins. So how will witnesses testify? What can they testify to? Will there be any limitations? The defense is asking the court to reconsider that ruling about the Commonwealth dog bite expert and medical cause of injury. What's going on with the ARCCA experts, because there's still outstanding motions on that. So there is a lot going on in court today, and it will be a busy one. I've got coffee. It's literally overflowing because that's what today's going to be like. We might need to make a second one. Have I had breakfast yet? No. At some point, will I be eating on stream? Yes, it's fine. We're going to have a very full day in court. So grab some food. Let me know where you're coming in from, what you're drinking. We're going to roll the intro. We're going to go to court. That's what we're doing today. We're just going to be in court all day. So law nerds, it's time to go. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
And yes, I was off last week. We will talk about that more when we get to a break, because I don't want to delay going to court any more than you do. And I want to drink my coffee, like dual purposes here, just being real transparent. But we had covered the habeas petition that was denied by the court midway through last week. We will talk about that denial later and the legal grounds for it. Those were always legally difficult grounds. There was one I thought that was a better opportunity than the others, but those were always legally difficult, especially when it comes to the jury. So we will talk about that more in depth later, but that is being appealed. So there is still a federal track for this case. That's not going to intercede with this going to trial. That is a very difficult legal path for the defense and an unlikely legal path. It's not going to derail this trial. I expect they will be starting jury selection April 1st, 2nd, 3rd, right in there. So we will see this trial get underway in just a few weeks. And that's why they are zooming through these motions. This is the very busy time right before trial. So it's going to be a busy one. They might throw in another hearing, but right now it's today, tomorrow, and April 1st are the next 3 hearings. Maybe we'll get another one. Maybe we won't, but you guys, it's going to be a day. It's going to be a full day. It's going to be a full day. And don't worry, when we get to breaks, we'll talk about other stuff. There will be breaks. I tried to catch it. So we got the hear ye's this morning, because damn, I miss them. I do. I miss the hear ye's. It's a part of us. It's a part of all of us now. So we need to get to court, because live court is what we do here. And God, live court is a lot of what we are going to do here. I saw a great question in the chat. Has she ruled on the motion to dismiss yet? She has not ruled on the motion to dismiss yet, though I imagine that we are not going to see the motion to dismiss get very far. Maybe we will see some strong words towards the Commonwealth and the videos, but the normal, we'll see. On most courts would keep the video out. That doesn't help the defense here, but I don't see the motion to dismiss getting granted. I think that is a long shot. Will that set up an appealable issue down the road if Karen Read's convicted? Yes, it will. But do I think that we will see that? I really, really, really don't think we're going to see her grant that motion to dismiss. It's a difficult standard. It really is a difficult standard. We'll talk about that more in other content. Don't worry. All right, buckle up. Let's go to court. Hear ye, hear ye. I'm gonna bang the gavel again because I like it. I missed you guys. All right, let's just go to court. I'm not ready for a full day of Brennan's voice. Are you? For all of you asking, yes, we had family time over spring break. My parents came to visit. They brought norovirus with them. It was a long week. We'll talk about it later. It was not so much of a break as me keeping the house smelling like Lysol, but we will chat later. Let's go to court. We'll chat at a break. So I missed you guys. It was not much of a spring break over here.
Yay. All persons have any business before the Honorable Beverly Canoni.
There we go. There we go.
Give your attendance, you shall be heard. State the Commonwealth of Massachusetts. This court is now open. You may be seated.
Hear ye, hear ye, hear ye. Hear ye, hear ye, hear ye. Hear ye, hear ye. Look, I'm glad I don't have norovirus. This week I did not get sick, so I got to take care of everybody. So it was what it is. Hear ye, hear ye, hear ye. I know I forgot to do EDB air today. We'll EDB air at a break. I promise.
Versus Karen Reed. Can I have counsel identify themselves?
I know it was a bummer.
Commonwealth.
Good morning, Your Honor. Laura
Hear ye, hear ye.
Good morning,
Hear
Mr.
ye, hear
McLaughlin.
ye.
Good morning, Your Honor. Adam Miley for the Commonwealth.
Morning,
I love
Mr.
it so
Lally.
much.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Each court has its own little
From the street.
Morning, Mr.
quirks.
Jackson.
The hear ye's make me so happy.
Also on behalf of Mr. Good morning, Miss Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti.
Also, I want
All right.
my hair to
so
be
we have
that
a lot
thick.
to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCCA.
Oh,
So
this was something that was pending decision, and we are going to be starting with the court giving an oral ruling. I was stalking the docket yesterday, so we're getting a ruling from the bench on the ARCCA experts. This is not common for this court. I'm sure there's also a written order getting ready to publish, but let's hear about the ARCCA experts. No spoilers yet. I know we're a little
told
behind real
counsel
time. It's
before
our prerogative to do
that I
so.
had reviewed. So first we had full
need Zoom
hearing
time.
from counsel.
We did have a full
I
hearing.
heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read
Man, my
that
notes are
transcript.
barely open at this
And I've
point.
certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here.
Wow. Oh, she's still pissed. She's still pissed at Mr. Jackson. However, you got to turn that shit over. She's still pissed. Oh, boy. However, if she's going to exclude this for discovery, you got to keep the same energy. She's not wrong about the candor, chat. She's not wrong about the candor. We'll see what she does from here, but she's not wrong about the candor to the court. It just needs to be the same energy for all the lawyers. Truly. All right. Let's keep going. Let's just keep going.
There has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated
Oh, shit.
misrepresentations made to the court by defense counsel, and I conclude that they were deliberate
Oh,
concerning
shit.
the relationship with the ARCCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses. Yet on February 26,
That's a problem.
2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate.
That's not good for the defense. That payment was made and Attorney Little put in the motion that they were not paid for. It's a problem. We knew it was a problem. What she's going to do, we'll see. But she is finding deliberate behavior on the part of defense.
And transparent attempt to keep exculpatory
I need to change my
testimony
glasses.
of neutral expert witnesses from reaching the jury in this case. The next page.
And they did correct the record on that,
Ironically,
but they
the
filed
Commonwealth
it.
accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control.
Yikes.
Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude
But what
that
are you
was
going
a
to do?
material misrepresentation. And
Here's where it sucks for Attorney Little. I don't know if Attorney Little knew that that payment was made. And that sucks because I don't think Attorney Little knew that Jackson's firm had paid it and Jackson needed to disclose that to the defense team and needed to read that motion that he signed and give Attorney Little the heads up. So all of you are asking, what about the Commonwealth? We'll get there because she is just covering the defense right now. But yes, there have been misrepresentations by the Commonwealth too. She's only focused on the defense right now. But the sidebar conversation was going to be a big deal and the filing was going to be a big deal. Little is part of Jackson's firm, but I don't think most attorneys know when a bill is paid, especially if they're not lead counsel. I just don't know. I haven't seen anything that indicates to me that Attorney Little knew that and then went ahead to write something misleading to the court. I don't think so. But I put that more on Attorney Jackson to make sure everybody knows before they file these motions. It's a problem. It's a problem. We knew it was going to be a problem. Let's see what she's going to do about it.
that it was deliberate.
Deliberate's a
So
problem.
I find that there is a flagrant violation of the Rule 14
That's
obligations.
strong words.
And before I decide which sanctions are appropriate,
She's going to
I
let
need
them
to see
talk?
Defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So
She doesn't know yet? You don't know yet? Oh, we're gonna back that up. They're going to sidebar. She has found a flagrant violation of the defense's duties. Here are some of the options. She could keep the ARCCA witnesses out. I don't think that's a good option. She could, in theory, remove Alan Jackson from the case, but then the case doesn't go forward to April 1st. She can fine and sanction through monetary fines the defense, which is probably the cleanest option, because if she kicks Jackson off, this case is going to get kicked out another 6+ months because she can't force it to go to trial in April. So is she going to care more about the schedule? But she can monetarily fine the attorneys as a sanction. She can sanction the witnesses. She can remove Attorney Jackson. Do I think she should? I think it's going to be a problem if she does, but geez, she's pissed. I'm going to back that up real quick. We're going to listen to it one more time, and then we're going to zoom right past the sidebar.
moreover, here, the defense has gone above and beyond its
I'm going to go back. We're going to watch this one more time, and we'll zoom through the other stuff. I'll put this at 1.25 because these are strong words from the court, and that's not 1.25. What we don't need is a sleep timer, Emily. We need to speed this up a little bit and listen to it one more time. Wow.
that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations
The repeated's
made
a
to the court
problem.
by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty...
I said I wasn't going to pause, but if you go back and watch the hearing where they talked about this, I want to go back and watch, and I'll probably do it for quick bits for next week. The sidebar was a big one. Attorney Jackson apologized and said that he thought they were talking about something else. The court obviously is not taking that very well, but it was a misrepresentation.
Clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses.
And then the
Yet,
filing.
on February 26th,
Yep.
2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent
There's not
attempt to
enough
keep
coffee for
exculpatory
this.
testimony of neutral expert witnesses from reaching the jury in this case.
This morning's coming in
The
hot.
next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations
The
under Rule
inflections
14
stand out more when I
and turned
zoomed it
over
up.
all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are.
I don't understand why she doesn't do this in chambers. I don't know if this courthouse is not well set up for that. This, again, is not a courthouse I have been to. I don't understand why she doesn't go into chambers with the reporter to do a colloquy with the defense and instead does it at sidebar. She's going to do it at sidebar. We're going to zoom past that sidebar. But she needs to talk to the defendant.
Before I figure out exactly what I'm going to do.
I'm surprised she doesn't know what she's going to do. Again, sanctions that are available. Sanction the attorneys. They pay that out of their pocket, and they sometimes have to report to the bar because it's a disciplinary action. Removing an attorney, which is easier to do when an attorney is pro hoc, though we've seen cases where the court has tried to do that, or I've watched cases, not with y'all, where the court has tried to do that. It's very appealable. Removing a lead counsel this close to trial is not easily done. All right, they're going to come back on the record. What are the other sanctions? You can keep the witnesses out, but I don't love that option either. A lot of you are saying no pre-warning. Michelle asked, and I saw a few other ask, no pre-warning or show cause. They had hearings on this. So this is, we went through the hearings on this. They did hearings on this. They broke the hearing that got paused for like a week was in the middle of this. And then Alessi came and did almost a full day of hearings regarding this. So this is the finding on it. Remember, I told you the court was going to take more issue with representations to her than with discovery issues. So that's what we're seeing. The court taking more issues with the representations to the court than with discovery violations. Let's keep going. This is Angie B. asked a great question. How often are defendants brought to sidebar? Oftentimes when there needs to be a colloquy with the defendant that is separate and apart from the prosecution, the court will either have the prosecution leave the courtroom and do it in the courtroom, which happens with this much media. That's not a real possibility. Or they can go into chambers with the court reporter and have that colloquy in chambers. So bringing the defendant up to sidebar is a remedy because there's media in the courtroom vis-a-vis having the prosecutors step out or going into chambers. And I don't know if chambers are large enough in this courthouse to accommodate this defense team with all the attorneys, plus a court reporter, plus the defendant. So let's keep going. Oh boy, today is going to be wild. I saw a couple questions. A lot of people saying she's too personally involved with this. I want to make clear that most judges will take issue with attorney misrepresentations to the court than discovery violations. I'm not making that statement about this judge. Most judges, that duty to candor means more to them than discovery that can be remedied other ways. Our entire court system is hinged on the attorneys being forthcoming with the court, and we have seen misrepresentations from the Commonwealth and from the defense here. The Commonwealth has now started correcting the record, but the history of this case with new Commonwealth counsel is much shorter than with defense counsel. But that's not just particular to this judge. This is particular to most judges. If attorneys make misrepresentations to the court, it is treated differently. So it's treated differently. Let's continue on.
All right. So there's no greater constitutional right than the defendant's right to a fair trial.
Yes.
Including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
He is now. He's going to say that he is, even if he isn't. So the colloquy was, hey, these are the options. The judge can sanction the defense team and still keep moving. It's not something that happens commonly in criminal cases, but it happens. It happens much more commonly in civil cases. But the judge is going to say, your attorneys have done this. Do you want to keep going with your attorneys? I imagine the answer from the defendant is, fuck yes. I'm summarizing. There's no way a defendant would say, well, I don't think this defendant would say that to the court. Emily, we've watched the Darrell Brooks case together, but has explained the colloquy is a conversation with the defendant, letting the defendant know that sanctions can happen and what those sanctions can be, and advising the defendant of what those rights are and asking the defendant if she still wants to proceed. I think there's no way this defendant's going to say, I don't want to proceed with my counsel. I think the defendant's probably sitting there saying what the chat is sitting there saying, but what about what the prosecution has said? And I imagine the defendant doesn't see this as the end all be all of the world. I think the defendant would probably view this as her attorneys fighting for her. Let me know how you view it.
We don't define our roles in such a manner, Your Honor.
Okay, so
Okay.
because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself.
Oh, shit.
But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential.
That's a
It's the
big
bedrock
warning.
obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word.
It's true.
And I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no...
You know, Your Honor, it's not just the defense. The defense is getting pulled into the principal's office, but we've now seen the prosecution have to correct the record multiple times.
place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time.
Oh, God.
So,
She's just using his words against him.
Commonwealth, I am denying your motion to exclude the ARCCA witnesses.
Okay, there it is.
Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan.
Principal's office.
I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that.
Okay.
So
Not even a
we'll move
sanction.
on to-
Those are really strong words to not even find them. Really strong words to not even find them. So the courts allowing the ARCCA witnesses to testify have given a public tongue lashing to the defense and reminded them that she is displeased, but stopped short of sanctioning the defense, did not remove Alan Jackson from the case, and is allowing the witnesses to testify. So what was this? A scalding. It was a finger wagging. It was just a don't do it again. I'm surprised she didn't even reserve the right to sanction later. Truly, I'm surprised. I'm surprised. The words were big mad, but the actions are not. I'm very surprised she didn't say I'm reserving the right to issue sanctions to the end. Okay. So, scalding. Everyone got a principal's office talking to. ARCCA's testifying. If any more discovery needs to be turned over, Jackson's not going to be removed from the case. Nobody's getting fined. And that's it. So that's it. She's mad. Everyone now knows she's mad. But at the end of the day, the ruling is fine. Okay.
Mr. Alessi, you didn't have a chance last time on the
Poor Mr.
motion
Alessi.
to
It's just like,
exclude
God
the
damn it.
testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
Good Lord, getting called to the principal's office very early in the morning. Alessi's making an argument now with regard to, we haven't even gotten to the motions in limine yet, with regard to the motion to, I think it's restrict the testimony of Dr. Wolf. If all of you are like, do attorneys like getting yelled at like that? No, but at the end of the day, the attorneys will take it because they are a shield to their client, and the attorneys will take the yelling at. The ruling is on their side. So, okay, you've yelled at me. Fine. Let's continue. So Wolf is one of, there's two Wolves. This might be the tech one. Let's listen to Mr. Alessi. Mr. Alessi, bring us peace and calm. And organization. and you're remarkable. Pro, which is what it looks like. So for all of you asking, what about the Commonwealth? There's no motion pending with the Commonwealth. This was pending on a motion. There is no motion. The defense keeps bringing it up. They will keep bringing it up. I think if I was the court in this situation, would any judge be mad if somebody misrepresented things repeatedly and put it in a written motion? Yes. Any judge would be mad. What I think a lot of judges would do is the Commonwealth has also corrected the record. I don't want to see any more record corrections. I want you to be careful with your words. Do not make assertions to this court unless you have factual backing for them. I want all counsel. So it would have started there and then backed up with, I want all counsel to be more careful. That's what a lot of judges would have done. This judge did not.
May it please the court.
That's a pleasant morning for everyone.
Proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr.
All right, this is
Wolf's
defense
purported
motion to exclude
testimony
Dr. Wolf.
by his own report and the Commonwealth's own motion is that Dr. Wolf will
I don't know if this is the
testify,
WOLFE Wolf.
is proposed to testify as to the cause.
I didn't know they were hearing the Dr. Wolf motions today. I'm just going to take a minute to tell you that I am wearing my Twilight shirt. So I felt like I was ready by accident. So just so we can all take a minute and say, Emily, we're talking about Dr. Wolf. Yes, I'm prepared. We'll talk about Twilight and spring break later. Let's continue on. Dr. Wolf is not the dog bite man. Dr. Wolf is not the dog expert. I know it would be amazing. I want Dr. Wolf to also be the dog expert. This Dr. Wolf is not the dog expert. Emily Ippolito, yes, we'll talk about it later. Yes, that comment is very well taken.
And
yes.
the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that
Thank
he's
you. This is the
qualified,
neurologist. I appreciate you,
prong
Chad.
one, and two, that the methodology
so many motions.
is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community.
All of you now know the standard for Daubert Lanigan better than most
Can
lawyers.
satisfy the 5 non-exhaustive factors of Daubert Lanigan.
All of you are just like, we got it.
The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community.
This is a
It's not
new
alleged,
expert for the Commonwealth.
let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation,
Alyssa would be
is
such a good
cause
law
of death.
professor.
You need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism.
Also, if Dr. Wolf is coming in to testify about manner of death, and the question you next are going to ask me is, Emily, isn't it unusual for the Commonwealth to call a witness that isn't the medical examiner that works for the state to come in and testify about manner of death, and to have somebody in addition to the medical examiner come in and testify about manner of death? Yes, it is. But from the first trial, remember that the medical examiner testified fairly consistently with the ARCCA experts about the manner of death. And there are motions in Limine talking about the manner and death and cause of death. So we're going to get into that more. We're going to get into that more today, I am sure. But this is about a new expert that the Commonwealth wants to bring in that the defense is trying to keep out.
Of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph.
Oh, read it.
And the applicable aspects of that paragraph is he says the following. Based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist.
Well,
and his focus,
I think neurologists can talk about head trauma.
By his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently
Well, that's much
does.
different. I'm glad he's doing that work, but that's much different.
Qualifications to talk about manner of death. He doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury. and mechanism of injury is irrelevant. So on qualification prong, Your Honor,
On this, honestly, I'm like, you know what? Let the Commonwealth expert come in, but also let the biomechanical engineers talk about it. I think everyone can agree that John O'Keefe had an injury to the back of his head. The issue is what caused that injury to the back of the head. And this expert from the Commonwealth is coming in to say it was a fall backward, which is still where I'm at. But somebody coming in and testifying about the fall backward that is not the ME is different, because the medical examiner said it is trauma to the back of the head. Could be a fall backward, could be something hitting the back of the head. So the medical examiner is like, I'm not talking about the mechanism that caused this, and the ARCCA experts weren't allowed to. So there's room to either let it all in or not. So we'll see.
Completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge
Dr. Scorti-Bello being
didn't
the
even
ME.
venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So
Right.
here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but
Mechanism.
speaking to mechanism of injury.
Which
So
ARCCA
in
can do
terms
too.
of the paragraph that I was just citing in his finding, he says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support
for that?
That Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death.
Well,
he provides zero.
I think there's an
basis,
argument it's a mechanism,
zero,
but there can be, how
for his conclusion
how do you
that Mr. O'Keefe fell backwards?
line out all the
Where
other
is that?
manners?
There's,
to
and
come
it's
to that
also
one?
not in the autopsy.
Right.
And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin
I mean, wouldn't it be the
state
water
how
content in
he
the ground?
concluded
We've
the
had
ground
lots
was
of
frozen.
law nerds
He wasn't
talk to us
there
about ground freezing.
on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to
The defense can
leaving
call the
his
ME.
lack of qualifications.
The Commonwealth will, but the defense can.
Where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors.
No methodology.
So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night.
Oh boy.
Which is they
should be done with that by now.
An article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old. And it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information.
Sounds like it.
But it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is.
That's a fair point.
With regard to a decedent.
Right.
And that's
a fair point.
Back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his 1-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury,
which is different,
which scientifically is completely different from manner of death.
Emily, keep listening.
What it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain?
Like what's the difference between a motorcycle crash and a backwards
injuries.
fall? Which
so this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points.
Explicated.
Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death.
Right.
So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin, and in the alternative, we would
For voir dire.
request an evidentiary hearing because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Daubert inquiry?
All right.
Okay.
Thank you.
Commonwealth.
Brennan.
This is the defense motion to exclude the Commonwealth's neurologist. This is a new expert. The defense is asking to exclude that witness. Are there charts? The defense is asking to exclude that witness or, oh, no, that's a binder. Exclude the witness or at a minimum
Yeah.
hold
Please.
a voir dire where they bring in the expert and ask the expert questions.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon.
Okay. But does he
addition to his
determine the
opinion,
cause?
You can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached.
I mean, that's not really the standard, though.
In his internships
He has to do like the thing,
as a
though.
neurosurgeon, he engages in
Neurosurgery?
an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country.
I didn't know that.
He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list.
But does he,
Page 3 of his resume.
it's the determining the things
His
go together.
research is broad and precise and specific to head injuries.
It's broad and
We
precise?
can see in his research
Counsel.
listed on page 4, he's a principal investigator
Those aren't
in
synonymous.
treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published.
The court had a full almost 2-day hearing for the defense expert with regard to, yes, she treats these types of injury with Dr. Russell, but in treating these types of injury, does that mean she can determine the cause of this injury? And I don't see how we're in a different situation here. He treats these types of injury, but what does he do to determine the cause of the injury? Because if you're the neurosurgeon, isn't determining what the injury is not necessarily the cause, the focus, because, well, the injury is there. What caused it might not be as relevant to the surgery that you're doing. What it is seems to be the thing. So I'm curious to see where this goes, because just because you can treat a thing doesn't mean your focus is determining the cause of the thing.
His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries.
But are you determining the
He
injury
has
or are
numerous
you
journal
determining
articles,
what caused the injury?
a slew of them, specific to head injuries. Intracranial pressure, number 2 under journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16,
questions.
which is the document that I produced to
Stephanie, yes.
counsel last night, listed.
Dr. Russell
in his
also
journal
worked as
articles,
a
number 16.
pathologist, a forensic pathologist.
Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. Presentations.
I'm sure he's great at what he does. The question is this what he does?
Basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references.
Again,
Lectures
I'm not
and
doubting that
meetings,
he's a
many of
qualified
them dealing
doctor
with
to
head
do the thing
injuries.
he does. Is this the thing he does? What was his
Over
methodology?
100 lectures listed for reference.
Okay.
Actually, over 130.
On what topic?
And a number of web publications. So this neurosurgeon,
I have a number of web publications.
who has this extraordinary experience, is qualified.
Oh, I hear my husband. Hold on. Hey, Dr. B.
The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr.
I muted at
Wolf
the right
is
time. My
far
neighbor was
superior
leaving the
to any
neighborhood.
pathologist.
Code 3.
The difference is a pathologist treats patients that are already dead. Dr. Wolf treats
One would
patients that
hope.
are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab. He's intimately familiar with assessing the injuries after they occur,
Okay, but Dr.
diagnosing what the
Russell,
injury
too.
is, and an attempt
Dr. B
to
wasn't
save
code
the
3.
person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as
Odd way to say
counter-coup.
it.
And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The
We're gonna have a
periorbital
lot
ecchymosis
more
that is directly related to the basal fracture, the swelling
experts.
around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter-coup and
If that's his conclusion, she's going to let that in without a hearing.
periorbital ecchymosis
'Cause
is
that's
in dispute.
A diagnosis
that the
that has a
simply
specific
prefers
mechanism.
the original medical examiner for the Commonwealth.
Well, the Commonwealth
We
will probably
expect
call
to
both.
Dr. Wolf, and I would suggest that he's more than qualified.
Yeah, I don't know if she's going to have a hearing on that.
Thank you. Mr. Ellis, anything final?
Yes, thank you, Your Honor.
Elizabeth asked, was the victim on his back when he was found? Yes, he was.
Your Honor, I'm going to note what Attorney Brennan did not
I don't think
state.
she's going to ask for a hearing
He
on
did
that.
not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated.
It's going
you have
with
to have either
diagnosis.
common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify
Manner and cause of
about
death are
cause of
different.
death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction.
If a neurosurgeon says that the injury to the brain is X and the cause of that type of injury is Y, and that is a specific type of injury that is a injury that requires higher velocity, then you really just have a differential diagnosis like Dr. Russell. And that puts it in the same category as Dr. Russell. That goes to a medical diagnosis of the cause of that injury. I don't think the court's going to ask for a voir dire on this. I don't. I think the court's probably going to allow this in. And I think we'll see the Commonwealth call both the ME and this doctor. And then we'll see, because the defense has a pathologist. If the defense is allowed, well, and I don't think anybody's disputing it, if the defense is bringing in their own pathologist and Dr. Russell, we're going to see the Commonwealth allowed to bring in the ME and this doctor as well. That's what we're going to see.
To limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies.
I think it's a fair ask. I just don't think it's going to fly.
Talk about manner of death, because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death.
You guys have great questions. I'm holding on to them.
Later, without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney
All right, you guys, I'm going to remember to take my
concedes it
supplements today.
by his own words. He said cause of
That's
injury.
what we're doing.
And again,
I think he can talk about cause of injury
only,
and not manner
will
of death. I think those are
concede
different.
Cause of injury.
I think that's
But
fair. I think that's a
manner
fair
of death
narrowing.
Was not addressed by Attorney Brennan.
think
It's
it's a fair
not
narrowing.
addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Dalbert factors. Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to
Again, I
find
lean
that
towards
he is
let all the
not
experts talk.
qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the records,
And then let ARCCA talk
presented,
about mechanism as
including
well.
the CV,
Fine.
etc.,
Let the jury decide it.
there's not one instance where we see that Dr. Wolf has...
Also, in practicality, I appreciate what Alessi is doing. I appreciate the parsing of the difference between manner of death and mechanism of injury. I appreciate it. I think the jury should just get to hear all of it. Just let the jury hear it. Let the jury hear it from the biomedical engineers. Let them hear it from the, neurosurgeon. Let the jury hear it. Let them decide, because that's ultimately for them. And let whatever the ME said, which was undetermined, stand. The difference between, we'll talk about the differences in manner and cause of death in a minute. I say let it ride and let the jury hear it. And I think that that's fair. Ultimately, is this a distinction without a difference for a jury? Because if you're sitting there on the jury through 3 weeks, does the difference between cause of death and mechanism or manner of death and mechanism matter that much to you? Probably not. This probably doesn't matter to a jury like at all, because the activity of the brain and what could cause that activity to cause swelling in the eyes and the rest of it is going to be more important to them than whether you call it mechanism or manner. So I say let the jury hear it all and let them decide. That's where I'm at.
even approach.
But I don't think he can call it manner of death. I think that's fair.
Or manner of death at all.
Let him talk about mechanism.
I don't see
Fine.
where there's a record to
Fine.
find him being able to do that for the first time in charges of this nature. Thank you.
Do you want to respond at all, Mr. Brennan?
I think that's a fair distinction.
At some point, arguments become semantical and theoretical,
Great,
but
sit down.
not practical. This doctor has treated thousands
That
and
was too
thousands of
snarky.
patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations in the study of the brain and the patients,
Can we agree
it is obvious
that he can
it
talk
is
about
obvious
the
that
mechanism of injury?
neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically,
I
he
think
could do
mechanism
that
is
if
fair. I
that
think manner is
satisfies
an overreach.
Mr. Alesi, but that is so
I've
unnecessary
ruled.
because it's
move on.
obvious. Thank you.
I'm not in charge here.
Okay.
But I have ruled. Let's move on.
You.
Before we move on, a lot of you in the
All right,
chat
so
are
we have-
asking, and this is why you have a lawyer to help talk through the things. The manner of death. We are talking about like three different things. The manner of death vis-a-vis the mechanism of injury vis-a-vis the cause of death. In this case, the cause of death is the head injury and hypothermia. The cause is like, what is the thing? A heart attack, head injury, gunshot wound, whatever. The thing is the cause. The manner of death is a coroner designation about whether or not that is accidental, natural, unknown, or uncategorized, homicide at the hands of another, which isn't necessarily illegal, that it'll go to trial thing, but at the hands of another, or suicide. So those are the manners. Those are the categorizations. So I think where we get to with the neurosurgeon is that mechanism makes sense to me. Manner of death becomes a determination for the medical examiner that has more of an investigative component. So I understand separating that part out. So hopefully that makes sense in the difference between manner and cause of death. And then the separate aside, which is mechanism of injury, which I think is the more important part here. And if they're going to open up the door to the dog behaviorist talking about the dog injuries, then I think it opens it up to the biomedical engineers also talking about mechanism of injury, because they also study the way the brain moves in a head. It's dynamic. So we'll see what happens. But that's the end of that motion with regard to Dr. Wolf. Let's continue.
The series of motions in limine. I'm going to start with defendant's motion.
On to the motions in limine, of which there are a ton. The defense has made motions in limine, just so we can run it down. The defense has made motions of limine, and unless any got filed this morning, these are the kind of broad overview of those motions. One, to present demonstrative exhibits, excuse me, based on their witness, Christina Hanley. One, to exclude, this is the title of the motion, irrelevant, inadmissible, prejudicial, prior, bad character, and propensity evidence. If it's all of those things, it probably doesn't come in. There's a couple motions to impound, motions to exclude certain witnesses before and after testimony, which is a sequestration order so that they can't be in the courtroom. Motions to prohibit testimony regarding funds paid for the experts, for voir dire, attorney-conducted voir dire, order prohibiting the Commonwealth and agents from having witnesses or contact with witnesses once they're on the stand. Contact with the jurors is a separate motion. To exclude the plasma blood serum retrograde extrapolation from Karen Reed. To allow evidence of lack of bias. I'm interested to hear them argue that one. That's going to be regarding ARCCA. To allow counsel to state grounds for the objections in court. I want to hear argument on that. I don't know if she's just going to say no right off the bat and we won't hear argument. And then we've got all the Commonwealth motions in limine, which include admitting photographs and sequestration orders, and then excluding the victim's family from the sequestration order, to redact the manner of death from the death certificate, to introduce certified records about the registry of like Karen Reed's car, which I imagine the court will just approve and they won't even argue, to order proof. This is an interesting one. Prior to calling the Norfolk DA and victim witness advocate as witnesses. I want to hear argument on that. There's motions regarding the Celebrate demonstration, regarding using demonstratives in court, regarding victims out of court statements, which are going to come in, to use the defendant's blood results. So there's multiple motions on that one. To preclude bad character evidence, to prohibit reference to any pending IA investigation. That's going to be really interesting. I want to hear argument on that. Oftentimes, pending investigations do not come in, but I think this case is really unique in that way. To preclude the third-party culprit defense, which the court allowed in last time. To allow for attorney-conducted voir dire, which both people want, and to exclude some of the statements of Michael Proctor, which will be really interesting. So there's a ton of motions in limine, and as the court is getting there, we're going to hear all of those motions in limine. Nancy in the chat just said, is all this happening because it's a second trial? Yes. There are new witnesses. There is new attorneys, and they go through the motions in limine again. We will generally see kind of same rulings on same questions, but there are different witnesses, so there will be some different factors. So let's continue.
To present the
Into the
demonstrative
MILs.
exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
So,
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
this is
I have a
regarding
question.
exhibits.
Did you use this last time? It looks like...
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
Did
Motions
she
in-
adopt it? Was there... Okay.
Again, motions in limine help refine what the evidence is going to be in front of the jury. So this isn't all getting done at sidebar. The goal is to move the case forward once the jury comes in as quickly as possible. Also, I think all of these individuals were probably in Boston yesterday for St. Patrick's Day, which I imagine was a whole thing. So I don't know. I think I would have asked the court to schedule this for like the 20th. It's like, Your Honor, the 18th seems like a terrible idea. It's a terrible plan, Your Honor. Can we not? So we are on the first of the motions in limine to allow an exhibit to become not to allow a demonstrative exhibit to become evidence, not just an exhibit.
She did indicate, and that's part of my argument.
That's
Your
fair.
Honor,
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared
Chalk
in
means
the first trial.
exhibit A,
no
demonstrative.
dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was
So
not shown
demonstratives
to the
don't always
jurors.
get admitted. So why
The
should this
evidence,
one be
as the
admitted?
court will recall,
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
no, we would ask that it be used as
He wants
a
to use
chalk
it
and
as an exhibit, yeah.
That's introduced.
Why?
I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt
Chad,
it.
I don't know why they call them chalks in Massachusetts. They mean exhibits. They call them chalks. I don't know why. There was probably a long history and legacy to why they call them chalks. Who knows? Maybe it comes from writing it literally on a chalkboard. I have no idea. But it is a demonstrative that you show to the jury versus something that gets admitted as evidence. That's the discussion here.
One more time.
I don't know why.
For its authenticity or its accuracy, I should say.
It is fun to
that
say.
it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's a very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
I mean, so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this. This deals with.
Just pull it up so
glass.
she can see it.
Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last week.
No,
Right.
that's
This is
polycarbonate
more to the glass
plastic.
in the bumper.
This is
Okay.
The
Right.
glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens.
I think they're
material,
trying to
which were the 47 pieces.
simplify some of the
These were a bunch of pieces of glass that were originally from
Exhibits.
that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources.
I think they're
and
trying to
different and
simplify.
distinct between and among each other. We reduced the very complex. The court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the day of her testimony?
Gosh.
Ms. Little, do you have that transcript pulled up?
The court goes exactly to Miss Little. Exactly to Miss Little. Do you know? Miss Little has the
I remember
answers.
testifying. I remember seeing this previously.
I've got it. June 24, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her.
They want to put it in
on
as a
the
summary
witness stand, and
exhibit.
she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence. What matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll
Well,
ask for
that's
its
the only way it
submission
can
at the right
happen.
time.
All right. What's the objection, Mr. Brennan?
He said to some of the markings on it, so.
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the
So the summary of the
defense
report.
summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue. I say that because we learned last night, for the first time on a public airing of an episode,
What?
that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face.
What?
Never heard that before. So we
Wait,
have
what?
this evolving or new testimony, or statement rather,
Wait,
statements
wait.
about
What? On an episode? Was that yesterday? Chat, there's a new special, the Discovery ID special. Okay, I haven't seen it. HBO Max Discovery ID. Okay, I haven't seen it yet. Well, I guess I know what I'm doing tonight. I hate the title. It's all the chats like Body in the Snow. I hate those types of titles. I really do. Y'all know how I feel about it. But so there were more statements from Karen Reed in the special last night. And the prosecutor is saying that he learned, apparently Brennan was watching it last night, that Brennan learned that Karen Reed said that she pulled pieces of glass out of the victim's face when she came upon him, which would be consistent with the injuries to his face if they were from glass from the car. That's not consistent with what the defense was trying to argue at all. The defense was trying to argue that those came from a fist fight at a minimum. But what? Okay. I haven't watched it. We're going to listen to what Brennan has to say. This new trial is going to be very interesting. Just very interesting. But the glass, the car didn't have glass. It all had polycarbonate. But there was a rocks glass that went from the bar to the car, and that is the glass they're talking about. Not the car glass. They're not talking about the taillight. They're talking about a drink glass that John O'Keefe took out of the bar, like a rocks glass. Remember, the ARCCA experts made a cannon that shot like rocks glasses at the polycarbonate to see if the glass could shatter the taillight in the way it was shattered. And that was near the victim to the best of my memory. But if the glass was in okay, this is all new information. The more she talks, it's interesting. Interesting. So he is saying, I'm going to have to watch this tonight. We'll talk about it tomorrow. He is saying that Karen Reed said in another TV special that John O'Keefe took the drink glass out of the SUV and that she took glass out of his face. That's all new information. That's made, well, I think the prosecution theory of the case is going to change, but that's new information.
Statements from Ms. Reed suggesting that, and also There was another statement regarding.
I'm
claim.
backing up again because I am. Well, I guess I know what I'm watching tonight. We'll talk about it tomorrow. But statements made by the defendant out of court are going to come into this trial.
Last night, for the first time on a public airing of an episode, that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that.
That
And
is a new
also,
statement.
There was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face.
That's new too.
Never heard that before. So we have this evolving or new testimony or statement, rather. Statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes.
They don't
the
often
witness's
become
testimony.
exhibits, is the thing.
I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important. But looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
I think that's fair.
All right, so Mr. Jackson, what I'm
Holy
going to do is
shit.
just hold off. Hold off and see where the evidence
Patty
is.
says it was
what the
claimed.
two of you
He
talk
didn't say
about. Maybe
Karen
there's
claimed
some
it. I'm gonna have
agreement
to
you can
watch.
come up with regarding this. It's just, I need to hear more of the evidence again.
understand,
And I'm
This
going
is
to
gonna
read
get
the
tabled.
transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day.
Right.
Ms. Hanley. So I do think that if the court would keep an open mind.
Sure,
if Ms. Hanley testifies, then that would be the appropriate time.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something
I
want to explain.
I will
All right,
have to
great, thank
watch.
you. All right, so no action taken on paper.
Chad, I'm with you. I will have to watch because I don't necessarily trust Brennan's representations after we've seen so many of them not be accurate. So the court's going to hold on to this until closer in time to that witness testifying. When the court talks about chalks, she's talking about demonstratives that are not evidentiary exhibits. There is a difference between things that you can use to demonstrate to the jury and things that become marked exhibits that go back into the jury room. Oftentimes, demonstrations do not become exhibits. Reports and police reports don't become exhibits. The scientific report does not become an exhibit. So a summary of the exhibit, they are saying, look, you can't bring in the report. You can't bring in a summary of the report. You can show the jury, but you can't send it back into evidence. So it's kind of a two-pronged question. But the glass testimony was incredibly confusing because it's also numbered, and not all of the glass matched. So Brittany said it did come from Karen's mouth. I watched it. He's being truthful. Brittany, I don't disbelieve chat. Chat is bae. Chat is bae. But I'm going to watch it too because Brennan has made some statements that just are not accurate. So he has strained my credulity. Music to my soul said, can we do a members only watch party of that show? Not without my channel getting taken down for copyright from ID Discovery, unfortunately. But I will think about what I can do to share my thoughts on it with the members before tomorrow.
5:58.
We can figure it out.
So one question, the next motion I have
We can
is
figure
defendant's
something out.
motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence.
Character.
The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminated to admit the victim's
is-
out-of-court statement relating to his state of mind. So the Commonwealth's Binns and Qualls motion, does that address the the Aruba witnesses.
She's trying to group these together.
I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though.
These are 559 and 585. So she's trying to group together similar motions in limine to address them at once with the Aruba witnesses. So it's a 3-part series. Part 2 is tonight. Well, it looks like we got some figuring out to do tonight.
So the defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say, the Aruba witnesses. I don't, Marietta Sullivan, Laura Sullivan.
I think the Aruba witnesses were a miss for the prosecution. What do you guys think, chat? For those of you that watched the first trial.
Does this include the children as well?
This does not. This is
Okay.
limited. This argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not
Yeah, I think
include the Commonwealth's number 11, the Qualls, Vince,
I
the
also
defendant's statement.
chat for me, for those of you that are like Aruba witnesses, there was a trip to Aruba with John and Karen and like a large group of friends, and Karen got into a yelling match with someone who she thought was flirting with John or had kissed John, but it's like a longtime family friend, and there was tension in the vacation over that. The prosecution was trying to bring in the Aruba witnesses to show that Karen was upset with John. Again, one of the charges here is intentional volitional homicide, showing that she's like mad at him and was mad at him over Aruba, and then ergo she, backed her car up and ran him over with the car because she was so pissed about that. And it just seemed to me when that evidence was unfolding that, like a lot of things in this case, everyone had been drinking and was pissed off and yelled at each other. It seemed like a miscommunication because everyone was drinking. I don't think it was helpful to the Commonwealth's case. You guys know how I feel about the intentional homicide charge. I think it's dumb. I don't think it's proven. And I think that the trying to prove that this was an intentional running over somebody with a car, I think is a bit of an overreach, to put it mildly. So I don't think, after watching the first trial, I don't think much of that charge. So that's where I'm at. But it was look, she's mean. Okay. I think that once we got to the voicemails from that night, you could tell that she was upset with John that night. So I don't know if you need the Aruba trip. I think we learned a bit more about the victim on that Aruba trip, but it just felt like a side quest that didn't really help the finders of fact find the fact. So that's how it felt to me.
The victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant.
So I
didn't mean to interrupt, Mr. Brennan. Do you want to?
I just want to know if that is part of the Aruba one.
Okay.
So our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then...
Good choice, Commonwealth.
With it, but in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Good choice.
Here we go. All right. All right. So, Mr. Brennan, you can have a seat again, and we'll go through the defendant's one. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its
Unless
case in
the door's
chief.
opened. Good.
If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right. All
Okay.
right, so that was 5:59.
All right. That was 5:59 and 5:85. That makes sense. I think they, again, I think they should clean this case up and focus on count 2, but we'll see what they do.
The defendant's motion to eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Then that'll be granted.
So who's going to argue this for the defendant?
I mean,
I am, Your Honor.
Okay.
Hi, Attorney Little.
What's different this time around is
I'm going to let the court explain. We've moved on to the next motion in limine with regard to a view. Remember, the jury went out to 34 Fairview last time, and the Lexus SUV was there. They are asking again for a view, and the court's going to tell us what's different between this trial and the first trial. The Commonwealth's not objecting.
I am, Your Honor.
okay. So what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
I don't know if that'll be allowed, but we'll see.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view.
It's not
under,
common
Massachusetts
the defendant
General
goes to
Law
the view.
234A.
So I'll allow a view.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus.
Well,
if we
yeah.
can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are
Why?
you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle
How?
should be sitting in front of that home in totally different lighting conditions, timing conditions, and I think it can be misleading.
Really?
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that
That's a fair
there will
concern.
be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposals. So I need more information from both. So, Mr. Brennan, I'd like.
They should just plan the view, block the street on both ends, which wouldn't take very long, block Fairview at both ends for, 45 minutes, bring in the jury bus, bring in a car with the defendant, bring in the car with the Commonwealth, and then that's it. Like, that's all. Like, do the view, have the, whoever's in charge of the jury, whichever bailiff is in charge of the jury there, the attorney's there, at this point, probably the judge there, and then that's it. That's not difficult to do. It's not common that you have defendants go to the view, but this is an out of custody defendant. It could easily or more easily be arranged. So we'll see.
I'd like you to come up with
It's more of a
proposal
logistical
about viewing
issue.
the car, a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's
I
try
think it
and
makes
figure
more
out
sense to
some
have
of
the car there.
particulars. I would like to have Ms. Reed be able to attend, so let's figure
Okay.
out some particulars.
Well, there we go. I'm actually surprised by that.
All right, so defendant's motion eliminate to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry.
She did say 462. So we're moving on
576. So Ms. Little?
Thank you, Your Honor.
to two different.
I'm handling the motion to
I don't know what the camera just did. So the court's inclined to allow Karen Reed to attend the view and wants everybody to work out the logistics, which means the logistics will probably be hammered out when the attorneys have time to talk, and then that'll be addressed tomorrow. The court's grouping together the different sequestration motions right now. So the sequestration motions are going to be what witnesses can be in court and when, and then whether or not the victim's family can be in court and when. So Emily Ippolito said, is she being reasonable? Yes, I think very. But with an out-of-court defendant, I appreciate the court's like, hey, that's fine. Let the defendant go. Let's figure out the logistics.
exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21.
I should describe sequestration a little bit better. They're talking about witnesses being in the courtroom if I didn't explain it well. So they are talking about who can be in the courtroom and when. Normally, the sequestration is done after a person testifies. So last trial, we saw the victim's family that were testify as the first few witnesses and then be allowed to remain in court. So they are going to be going through the particulars of the sequestration order. Witnesses can't be in court or, in this case, observing court on television, YouTube, whatever, until they testify. After they testify, unless the order still stands, they are generally allowed to come sit in the courtroom or watch the proceedings. So they're going to talk about what the sequestration order looks like and whether or not the victim's family will be excluded from that sequestration order, meaning whether or not the victim's family will be allowed to be in court, even if they are testifying witnesses before they testify. So that's what they are trying to talk about, not excluding the victim's family, excluding them from the sequestration order, meaning they can be in court. So let's continue on with those sequestration orders about who can be in the courtroom and when.
The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but
Until evidence is closed.
so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court
That's
for
what she's
closing
asking.
arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all.
So generally, and I'm going to let Ms. Little make her argument because I think she argues very well. Generally, once witnesses are done testifying, they are allowed in court. So the defense is saying, yes, that's generally what happens, but there is a reason in this case why we want them to not be present, even for closing arguments. That wouldn't forestall them from watching it. They don't want them in the courtroom.
All seated in the jury box with the O'Keefe family.
They were?
At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a
I agree with Ms. Little that it's concerning. Normally, you wouldn't have what a juror thought. The layout of this courtroom is incredibly unique. A lot of courtrooms have the jury box to the side and then everybody sits at the end. This courtroom is more of a horseshoe shape. And so the victim's family sits dead across from the jury. So they are in line of sight versus the jury being on the side and the audience being to the back, which we've seen in most other courtrooms in cases that we've watched. So this layout is unique. And the reason she's saying third-party culprits is because the defense has brought in a third-party culprit defense in the last trial. They were allowed to. They haven't gotten to the motion in limine regarding that again. So that's why she's using that language, because that's the defense theory.
Close of the case is highly concerning.
Was this a deliberating juror?
I don't know. He or she was anonymous.
Okay.
To Vanity Fair.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with.
Again, when they say exclude, just so there's no confusion, when they say exclude, they mean exclude from the sequestration order, not exclude from the courtroom. So they're saying that there should be an exception to the sequestration order for the victim's family and the defendant's family. Everyone agrees on that. So when we hear the word exclude, we're not talking about keeping out of the courtroom. We're talking about excluding from the order to keep them out of the courtroom, which means allowing them in the courtroom. Hopefully that makes sense, because I can see where there's lots of room for confusion. So allowing victim and defendant family in the courtroom.
All right, so obviously,
and everyone agrees on that.
Something it should be in a motion, okay? If you've got an agreement that each other's experts can be in the courtroom during the testimony.
Oh, they don't need a motion for that. Experts are allowed in the courtroom. Experts are experts. They rely on other testimony. It's the point of being experts. Like, I don't know why that needs to be in a motion.
Me, that's one thing, but it's not obvious that they're permitted. Okay.
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right, so you all need to talk. All right, and
I mean,
if
that makes
there's a
sense.
disagreement, you need to put it in writing.
All right.
Generally, experts are permitted,
Yep.
but it's not a given, okay?
It makes
All right, Mr.
it only
Brennan,
makes
do you
sense
wanna
that
weigh in
experts are
on
included.
People being able to, I'm concerned about after the evidence is closed.
She's trying to narrow down the argument to just closing arguments.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and
Did she say
they
Higgins? I
suggest
heard
that some
Albert and
anonymous
McCabe.
person
Maybe she did.
was uncomfortable.
That's one way to go with that argument.
It seems as though the presentation has a deliberate point to promote a cause, but doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly, I would have a right to try to ask the court or insist that they should be sequestered. but I've specifically asked that they not be sequestered. I think
Three.
that an accused has a strong need to have family support in a courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court
Okay.
testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing,
All of a sudden, he's very soft-spoken.
not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea
Law, justness,
that these
and
targets
courtesy.
of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
So two different parts to that.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective
Damn
order,
it!
but I would like to make a record.
Ugh. All right. Well, now we're going sidebar. All right. Let's see how long this sidebar is. Brief. So we're going to zoom past the sidebar to catch up to whatever they put on the record. So the Commonwealth is asking that after testimony, witnesses are allowed in court, and that includes closing arguments, and that the victim's family and defendant's family be allowed to attend court even if they may be witnesses, so they wouldn't be excluded until they testify. They would be allowed in.
It's motion eliminate to prohibit testimony.
The court's back on the record, so I'm going to back myself up a little bit. All right.
All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
Okay.
That's also mine, Your Honor.
Okay,
Attorney Little, I love the suit today. I'm digging
I believe
it.
the Commonwealth has indicated that they will agree to that.
okay.
Okay, done.
All right, so paper 565, allowed by agreement.
All right, what's next? They're moving quick today.
So
go.
566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward.
Okay, we've moved into the subject of voir dire. Voir dire is the process of asking the jurors about shit. Panel voir dire versus individual voir dire seems to be what they are getting into now with the defense motion to conduct panel voir dire. At times, the court will conduct part of the voir dire or part of the questioning of the jurors, and then the attorneys will get to conduct part of it. Sometimes some courts don't allow the attorneys to conduct any voir dire. So each part of juror voir dire can happen differently. So the attorneys are making motions to be allowed to question jurors in different ways. What happened with the last motion was also about voir dire, that the attorneys couldn't bring up money paid to experts during the voir dire questioning of the jurors. And the Commonwealth agreed that that wouldn't come up during voir dire. That is something that will remain for testimony and cross-examination. So now we're talking about what you can and how you can proceed with the questioning of potential jurors. So that's what we're getting into now. Panel voir dire means everyone's asked the question, like sitting in the box, and they are all asked, versus individual voir dire where they're asked one-on-one. So now we are talking about how that process is going to work.
We would maintain a categorical list of topics. That is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to...
Okay. We covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is some, at least a modicum of panel discussion between
versus
and among the
one-to-one
jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay. What's the Commonwealth's position?
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument, in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And
Panel
so
voir
I think
dire
the questionnaire
can
is well
digress.
structured. It allows for all the different subject areas that are important to both sides, and I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary, and I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from,
Yep.
panel voir dire consistently, it's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
Exactly
so
how
I'm a huge
it is
proponent
common.
of panel voir dire in the right case. My biggest concern here, frankly,
It's high profile.
if we didn't have the inordinate amount of publicity on this case so
She's
close
right about
to
that.
trial. I heard that there was something last night. It's been in the news, right? And it's continuing.
She's right. I agree. I understand where Jackson's coming from, and I agree with him. I also agree with the court because panel voir dire, and what they're talking about is, I don't know how big the box is, whether it's 12 or 16 or 18, but what they're talking about with panel voir dire is putting everybody in the box and then going through the follow-up questions with the box. The problem in a high-profile case is that one person's answer can taint the rest of the jury. That's not necessarily the case if somebody comes in and says, I don't think I can sit on this panel because I have someone in my life that was impacted by drunk driving. That's a very personal thing. And so one member of a jury panel saying, I don't think I can sit on a drunk driving case because of this experience. That's different than somebody coming in and sitting down and saying, I don't know if I can be fair in this case because did you hear what the defendant said on this interview with Vanity Fair or whatever it was? That can have the rest of the jurors sitting there in the box going, what now? Tell me everything. So when you're dealing with publicity, it can let the shit out of the horse and impact the rest of the potential jurors. Again, different than personal experiences would. And while people may have empathy and sympathy for someone else's personal experience, it doesn't necessarily impact how you view the world. But once you put in that question of, oh, and then there was all this publicity, it's real hard not to go get on your little noodly googly and try to figure out what it's all about. And that can cause problems. So I really understand where the court's coming from with the publicity potentially being the issue with having the jurors be voir dired in a group, meaning they all sit in the, when I say box, the jury box, they all sit in the jury box and have conversation versus they all wait somewhere and come in one at a time. So it's hard. Kooky Carlin in the chat said, oh my God, I would start gossiping and speculating right there. Right. And it's hard in a high profile case. It's hard because if one person says, oh, I've been listening to this podcast, I've been watching, I saw this on Discovery, I saw this on local news, I heard it on Carson and Kennedy in the morning, it really can raise the curiosity of other jurors to go seek out that information. Different again than a personal experience that you're not necessarily, it's like, oh, that sucks that happened to that person that I don't know who's sitting here next to me. So I understand. And it might be that you panel voir dire for everything except, oh, that would get real tedious. All right, I'm going to let them deal with logistics. It's not me. I'm going to let them deal with logistics. But the high profile aspect can cause problems here.
It's because of that. I
cut the judge off mid-sentence. Well, she cut Jackson off mid-sentence.
Huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity
the high profile
on this case, so close to trial,
changes it.
I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a.
I've had cases, and my friends have had cases where the entire panel has to be dismissed because someone says something that can taint the whole panel, and it's like, all right, all 70 people that are sitting here today go home. We're going to have to bring in another group of 70 tomorrow, and you burn an entire day. So burning a panel of jurors is literally the worst thing ever. And having one person genuinely answer a question in an honest way can let the shit come out of the horse too fast. So I understand why she's making that decision. So the court's like, yeah, we're going to do individual.
Robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it. And if you can't, I need that. I need that by the end of today. If you're not going to agree to it, have you proposed a questionnaire?
So are you not doing your final
questionnaire recently?
I guess today.
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we can act on to start with.
So let's do that. What Mr. Brennan's new to the case. What I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in.
I imagine.
And I have some ideas on how we might best utilize that.
They're going to need so many jurors.
But I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case. Unfortunately, I think because of all the publicity.
I don't disagree with that.
And we'll do extensive voir dire at sidebar and the question.
I do disagree with that. I hate that.
So 566 then is denied.
This courthouse might only have a layout where you don't have anywhere else to keep the jurors and you have to keep them in the courtroom and do it at sidebar. But that makes sense to me to with the high profile nature of this case and the amount of media locally in this case, that you can't taint the whole pool by doing panel voir dire. I like it better, but
It's requesting panel voir dire.
I don't disagree with the court on that.
567,
I think that's cautious.
defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses.
So we're back to
once
MILs?
they've taken the stand. So,
That should be
is
happening
there an
anyway.
objection to that, Mr. Brennan?
That's
There's
just
not,
what,
I believe that rule should
That's
apply to
just
both
what
sides.
should
I have
happen.
no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay.
that's just how it goes. Yep.
All right. So
That's
that,
granted.
Mr. Clerk, 567 allowed as to both sides.
For all of you asking, when does this start? Jury selection is supposed to start April 1st. There will be some, I imagine, hearings that day. Jury selection will not be televised. And then jury selection will probably take a couple days, and then trial will start.
570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial
It's the strangest title ever.
evidence regarding alleged harassment and/or intimidation of witnesses.
That part makes sense.
All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what
I'm
we
very
believe to be
interested to hear
inadmissible
this.
and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe.
This is going to be a very interesting motion. I'm going to back this up a little bit. This is the defense motion to exclude any testimony regarding witness intimidation. And I think the Commonwealth, based on their prior arguments and based on their updated witness list, wants to get into this area even more. So this is going to be a really interesting argument over what the witnesses can testify about, because we've now seen the Commonwealth trying to get to cell phone information and going beyond what Lally argued last time regarding any perceived witness intimidation. So the defense is trying to keep all that out at the jump.
Of witnesses.
I'm very interested about this motion.
All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial.
Yeah, people want real world
in
in a
these
really
witnesses'
fucked up
testimony.
way.
To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these
They did imply
alleged
that.
and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it."
Yeah, that cross-examination
In
was
some way, shape,
feisty.
form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible,
shouldn't happen.
unacceptable.
Right.
There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There's an enormous amount of emotion
And again,
injected throughout.
that's fair, but you don't go real world with people. It's fair, but going real world makes it worse. Makes it worse.
Community, this community and beyond. and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her.
Yeah, Cal girl, I don't think anyone should go real world. That's where I'm at. I don't think anyone should go real world. I think people can have opinions. Everybody has different opinions. People shouldn't go real world. But I realize that is over idealizing the way things should be. I worry about access to courts in the future because of the way people go real world. I don't think any side should go real world, no matter how they feel. I don't think people should go real world on any side of any case. I think there's room for discussion. I think there's room for consideration. I think there's room for criticism. I think there's room for criticism of how this case has been handled. But that doesn't mean that people should go real world. It doesn't mean that social media harassment should ramp up to run people off the internet or whatever it is. We've seen it in multiple cases. I worry about how it will go when good experts will not get involved with cases where they're needed. Imagine if experts in this case, I liked the ARCCA experts' testimony. I think they were very, very needed in this case. But imagine if the ARCCA experts, for example, looked at this case, looked at what is happening online or IRL and said, I don't want to be involved. You can't subpoena us. We're not coming in to testify in this case. We're keeping it to the grand jury, and we're not going to involve ourselves. We're not going to involve ourselves. I think it hurts cases when you will have good experts that will not want to take on high profile cases when there is need for them because of the potential for personal consequence. And you're going to have courts get more and more nervous. We're seeing it in Utah. You're going to have courts get more and more nervous about allowing cameras in the courtroom. And I think that hurts everyone. I think that hurts all of us. I think we need to see what's happening in courts. But when people go real world, judges get nervous because the first thing they want to do is protect their case. And I hate it when people go real world. It's not this audience. I'm preaching to the choir. It's not y'all. Y'all, we chat here and keep it here and have our opinions. But going real world and harassing people hurts cases, and it hurts good experts. So, and we're not going to see them wanting to be involved in cases, which ultimately hurts people's rights. So that's where I'm at. I appreciate it. You guys, I don't need to tell you. We watch the cases unfold. Yeah. And I don't know how to fix that because harassment hurts these cases. It does. And it ultimately hurts access to justice.
What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable
I
cause
understand
standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth
is seeking to double
aware of
down.
that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued, indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27th.
Before the trial.
It was late March, before the first trial. And they knew this, and they didn't provide what I believe.
Many of you in the chat have said, we need to know about the ham sandwich. The saying goes that a grand jury could indict a ham sandwich. That is the saying. There might be more of a saying on that, but that's generally the saying because a grand jury, the standard is probable cause. We saw lots of fighting over grand jury in Idaho, so we're not going to get into it today, but the standard is low. It is a more likely than not standard when you're looking at it at a very baseline. So that is the analogy, especially for all our non-US audience who is like, what in the world? We have prelims, we have grand juries, we have state grand juries, we have federal grand juries. Our legal system is deeply complex because there's so many different parts to it. But that is the saying that anyone can get an indictment on anything. So to have a grand jury come back and not indict is actually more unusual than getting an indictment or a bill or a no bill, as they refer to it in Massachusetts. So whether or not you like ham sandwiches, that's what he's referring to.
What the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening
the door opened
with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant.
That's not going to help.
It was going to be very easy.
Read the transcript.
I have.
Don't fight with her, AJ. It's not going to work well for you.
Event, I believe that the court should make the exact same order.
That's not going to go well.
And have a more defined. We should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed, and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Miss Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, sidestep that.
It's really hard to make that call in advance, though. What will or will not open the door is very difficult to determine in advance. I remember the court ruling that the defense had opened the door in the questioning of Jen McCabe. The court had ruled that anything about witness intimidation wasn't to come in. And then the defense was asking, this is to the best of my memory, that the defense was asking for explanations of behavior, and that Jen McCabe couldn't fully explain that without explaining all of what was going on. It's very hard for the court to say, well, these things would open the door to allowing that testimony in. And for those of you asking, Emily, what do you mean by opening the door? It means that the court has ruled that something stays out. But the questions of a party can open the door for those questions to come in. you cannot open your own door. So the prosecution wants to bring it in. The prosecution can't elicit questions to open that door. That's improper. But if the defense does or asks something that makes it necessary and almost prejudicial to leave it out, then the door has been opened. And there are several ways that that can happen. We've seen it happen in other cases where the door has been opened and it's like, whoop, and we see it immediately. You stepped in it right there. That came in like a wrecking ball with that door, blew it off its hinges and everything. So the defense is saying, can you give us parameters of what would open the door? And that's real hard to do because the court's not going to say, well, I'm limited to these things. It really depends on what you say. It depends on the questions you ask. And that's part of sitting there as the attorney in the moment and making sure that the questions you ask don't cause downstream consequences. So it is, when they talk about lawyers having a lot going on all at once, you do. Because not only are you asking the questions and responding to the answers, you're also making sure that you do not cause other consequences. So that's what they're talking about now. I think the court is going to keep it out again. We'll see what the Commonwealth says. But once the door gets open, that shit gets open.
As best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance,
I guess you're going to read the transcript.
Clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously,
that's
would open the door.
Different, though. Explaining behavior.
That's not what happened last time.
Witnesses can explain their behavior.
McCabe basically decided that she wanted to talk about that issue and sort of walked through.
He thinks she was
at least
baiting
in my
it.
view, having reviewed the transcript.
He thinks Jen McCabe tried to open the door.
In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person.
I think Jen
after
McCabe
another
wanted
after
to
another walking
talk
into
about it
court
for sure.
and basically,
I don't disagree with you, Chad.
lambasting the defense, for all intents and purposes, about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Remember, the Commonwealth has intimated that they want to bring this in as consciousness of guilt, not that they are trying to say that a crime occurred. That's not the direction the Commonwealth is going. But in the last motions and argument we heard about this from the Commonwealth, they were trying to say that Karen Reed was giving information through third parties to put it out there in the public because she wanted the witnesses to not testify because she knows she's guilty. So that's the direction the Commonwealth has gone with that, because I think they're going to try to bring it in even more. Lally, it doesn't seem tried to go that direction at the last trial at all, but it looks like Brennan is going to try it. So I'm interested to hear what his response to this is.
Mr. Brennan.
I gotta turn on my heater. It is getting cold. The weather is very spring. It is hot, cold, swirly, wet, thundery.
I can appreciate the defense wanting to identify the line in which they would
Very
open
interested
the
to see
door
this.
to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked talked about speaking frequently to Mr. Carney, sharing anything
Really?
public with him. And you would
Damn
have
it, I have
to
homework.
choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used.
This is so messy. This is so messy. I want to know what's in the recorded. We're not going to know. I want to know what's recorded in the Gretchen Voss stuff.
By the defense and the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent.
Oh, boy.
I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue.
About the phones.
And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to.
Counsel, you lob quite a lot of attacks.
Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events.
What is happening? I'm backing that up. What? Also, Brennan said that Karen Reed was talking about sharing public information with people. You can share, you can share public information with people. Sharing public information with people is what every reporter sitting in the gallery does. It's what I do. Sharing public information with people is what all of them are doing. Every single person is all of them sitting there with the laptops in the back are sharing public information with people. That's literally okay. But I didn't know he said butts. I didn't catch it because now he's low talking, but watching the two of him and Jackson are going to try to out hyperbole one another. And it's wild.
Because it pleases them and fits their narrative.
He does exactly the same thing.
By and listen
just
to.
Exactly the same thing.
The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done.
He just said the Commonwealth wasn't outside patting bloggers on the butt for a job well done. What is happening? What? So that's going to end up on a t-shirt. Not by me. I needed to hear it again. That's ridiculous.
In the text of
was
their
that on court
argument,
TV too?
Unsolicited attacks, because it pleases them and fits their narrative.
Sorry, guys, I just couldn't.
Can't just sit by and listen to.
That's
the Commonwealth,
what?
The prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
Oh, boy.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay. So that was a lot. That was a lot of a record for we all agree. That's a lot of... He and Jackson are just going to keep bringing the drama up. It's defense attorney versus defense attorneys at this point. But it's going to be... Well, I'm interested to see what Jackson responds to. But what he said was, I agree, except for the things I've sought admissibility of. And we'll see where we get with that. Interested to see how Jackson responds. He basically said, do your job better to Jackson.
Your
He
Honor,
said,
if I may very briefly.
ask better questions, get better answers.
Just give me 1 second. I want to take one note. Okay?
Of course.
Oh my
All right, go ahead,
word.
Mr. Jackson.
I just wonder if
They need a
where
Housewives episode.
this
We need Andy. We need a reunion. We need Andy. We need a camera. Look, when I say we need a lawyer version of Traitors, I can see the casting. I can see it. I can see it because the level of them taking it up a notch is wild. Lally wasn't snarky. Brennan is snarky.
ire and these invectives.
I didn't let. Sorry, AJ. We'll let you go.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements.
He did say that.
Was he listening? I didn't bash a witness.
Jesus
I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort.
Jackson is
their
like, are you
best effort
high?
to tether Miss Reed to Aiden Kearney.
Who's sitting right there on a laptop.
And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation,
whether it's improper,
directing
right?
Witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying.
He's saying the
Maybe it all
connection.
happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very
Zealously
and robustly.
Zealously.
Let's keep it professional. I didn't stand up here and attack a witness, or what did he say? Bash witnesses.
He did say that.
Use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further.
I mean,
all we're asking is that it not come in, and I will stay
AJ,
and agree.
You're not alone in bringing the drama, though. Brennan is also bringing the drama, but sir, Sir, it's not like the drama has missed you, though. It's not like you are not a friend of the drama. Sometimes you are, in fact, the drama. It's just, we can tone it all down a bit. It's like drama meet drama. It's, oh, good Lord. Your Honor, can't we just tone it all down? Bring Mr. Alessi up. Mr. Alessi will tone down the drama 90% of the time, but the drama is not unfamiliar to you, sir. Like, it's just like, who, me? Am I the drama? Yes. Yes. Oftentimes, yes. Oh my goodness. I'm going to beg that. That's hilarious. It's just, good Lord.
Bash witnesses, use this as an opportunity to bash people. We could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief, and we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar.
I think going to sidebar and also asking, instead of fighting with Jen McCabe, AJ is going to have to ask the court, and I don't know how this will go, ask the court to admonish the witness to answer instead of him fighting with her. But him fighting with Jen McCabe, let me know your thoughts on it in the chat. Did it make her look evasive to you, your perception, as they were going back and forth? Or did it look like Jackson was being too aggressive? And it's hard if you came into this case with information because people had feelings about Jen McCabe before she took the witness stand. But for those of you that didn't, did it make her look evasive or did it make him look overly aggressive? And so there's a strategy too to then asking the court to rein in a witness versus allowing the witness to show who they are on cross-examination. So there's a lot of strategy to that. And we might see a completely different cross-examination this time than we saw last time. So it really depends. And asking the court to rein in a witness when they are seeming evasive can undermine what you are trying to show the jury as the lawyer. So we'll see how this goes, but it seems that they are... it seems that they are agreeing that that won't come in and that Jackson may be more surgical with his questioning of Jen McCabe. But I thought all of her testimony, direct and cross, was oversold.
And I think that could resolve the issue.
Okay.
So they agree.
Thank you. I'm going to look at this a little more closely.
Oh boy. My husband is cooking something that smells amazing.
All right, the next one is paper 571, and the
all right, moving on to
Commonwealth's
next motion in limine.
corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol
this
concentration.
is about the blood
conversion,
alcohol.
And corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth.
The Commonwealth is moving to bring in the retrograde extrapolation. The defense is moving to keep it out. That's a very broad summary of what they're arguing. So we've got two sides of essentially the same motion. And that's what no, we're not talking about Mercury and Venus retrograde. We're talking about blood alcohol levels.
argue their,
I'll ask Dr. B if he made
make
enough
their
for the
argument
class.
for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first, and
All
we
right.
would respond, including with regard to my motion.
Okay. So, Mr. Brennan, your paper, our paper 386, your number 12.
Not 386, 586. All right, the Commonwealth is going first on admissibility of the retrograde extrapolation, which came in last
Paper
case.
number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion in retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol.
Which we heard last time.
We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth versus Hallinan, 491 Mass.
I think this goes to
page
weight, not
736,
admissibility.
note 9.
But we'll see.
Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Alessi.
Thank you, Your Honor.
It sounds to me like when the court is saying Mr. Alessi's name, she smiles. It might just be me.
Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts,
That's for
as
cross.
well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical
that's why it
records
was
in the
arranged.
chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients.
Right.
And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two.
The issue here for everybody who's jumping into this case and didn't sit through all of these witnesses in the last trial, the issue here is that when Karen Reed went to the hospital the next morning, she had blood drawn because her father had called in a psychiatric hold. She had blood drawn at the hospital for treatment. And that is done differently than when there's like a law enforcement blood draw to determine a blood alcohol level. But then the results from the hospital were extrapolated by a different lab. And I am perhaps oversimplifying, but extrapolated by a different lab. And then they took those numbers and worked backwards using averages to average out her last time of drinking. And they had put her last time of drinking before she drove to 34 Fairview. So they had averaged it back to last time of drinking and then what her blood alcohol would be. And then that's cross-examined because that produces a range. And what they do at the hospital is for a different purpose than what law enforcement would do. There's also the issue of consent, because oftentimes you will need a warrant to take someone's blood to test for blood alcohol in the law enforcement setting, vis-a-vis testing for blood alcohol to make sure it doesn't have interactions with treatment or medication or things like that at the hospital. So the hospital's use of test is very different than the law enforcement use of test, and they are different tests. So taking the one test and then extrapolating it to a different taking the one test and then taking that blood serum and saying, okay, then it means it was this blood alcohol level, and then working it backwards to determine the level at the time of driving is different. And it also depends on averages based on how people metabolize alcohol, etc. So they are using a hospital-based test to make assumptions to a blood alcohol level and then working it backwards. This is all part of cross-examination. I think a lot of this goes to the weight of the evidence that the jury gives it, not the admissibility of the evidence. They're going to argue it again. I think the judge will allow it in again.
There is no record evidence, and it's the Commonwealth's
but he's going to
burden of
argue it
proof
again
to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish.
And I think the defense has to argue to
reliability.
try to keep it out again.
It is not enough for the attorney for the Commonwealth to simply to stand up in ipsy-dixit and saying they're reliable.
We got to
when there
ipsy-dixit
is a lack
today.
of the information of the factors I just rehearsed with regard to the matter.
This man loves the
And
Latin legal phrases as much as a law
another key
professor.
aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994.
You know,
serum
Alessi's
plasma conversion
never
report.
late to like
It
meet friends at
states
dinner.
2 paragraphs under the
He's
chart.
just like, reliability is
With
king.
an asterisk, the ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory's scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B,
I saw the question in there. Do lawyers spend a year learning the
In
language?
terms
No,
of-
you do it through casework.
changing that conclusion.
The law loves a
in
Latin
that
phrase.
statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas, chromatography, or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard. The testing that has been performed is not reliable.
All right.
It should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited.
That's not what the
And
defense
this
is talking
the same
about.
issue argued at the first trial, but inevitably Dr. Fowler's testimony is
That's not what he was arguing
what
about.
establishes the foundation for the admissibility.
Unless he wasn't talking,
Sure.
unless he wasn't talking about what happened at the hospital, unless he's talking about what happened at the state crime lab that took the way that they test blood alcohol serum at the hospital and then tested it for the other part, which I think is the ethanol part, and I don't want to get it wrong, but it's not the way it was done at the hospital. It's the way it was done after, Brennan. He keeps going, no, at the hospital it was fine, unless he's not talking about at the hospital. He's talking about after that. Are you listening?
Thank you, Hunter.
Again, it's
Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk.
all right. So docket 574 was
All right,
granted.
so what I'll do is I'll see counsel at sidebar regarding scheduling.
They're moving fast today. I'm not, because we're chatting, but they're moving fast today. Okay, they're going to sidebar, and it sounds like they're going to a morning break, so let's zoom beyond sidebar and the morning break. Let's see. I'm going to see if they put anything on the record before they go to fan, which they might not. All right, let's see what the court puts on the record.
All rise for the court, please.
You are muted.
And now on break. All right. So the court has left the bench for the morning break. Let's zoom beyond the morning break. And
round or additional briefings.
I zoom. I have zoomed too far, y'all. I have zoomed too far. Let's pass the morning break. I love being able to zoom. We don't have a lot left to go today, it looks like. So it looks like maybe a half day, chat. Hang in there. Let's go. All right. Back from the morning break. We're going to find out together, chat. I don't know.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to
That one
continue
motion.
the start of the trial, which is currently set for April 1st.
Mr. Jackson, not only do I have Metallica tickets in May, Emily, this isn't about you, but isn't it? Not only do we have things to do in May, But a motion to continue the trial, a motion to continue the trial. I'm going to let him talk. But we have a very carefully curated trial calendar that runs from April to November. You can't. What? Let's hear what he has to say.
Motion.
Thank you, Your Honor. I appreciate it. It won't take very long.
We have concerts to consider.
I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First
that's not going to happen. Okay, never mind.
Based on Judge
that's not gonna
Saylor's
happen.
opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts.
Yeah, that's going to be
If
denied.
the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly
They need to make
about.
the
We
record
all
for
do.
appeal.
Okay, Mr. Weinberg?
Mr. Weinberg, yes.
Okay.
Martin Weinberg.
So they need to make the
If,
record
in
for appeal.
fact, the First Circuit were to agree with our appeal.
All right, this
And we're to-
is less of a motion to continue and more of a I need to formalize our motion to continue based on the appeal so I preserve the issue so that when you deny it, if it plays out differently, then the grounds have been preserved. This is more of preserving the appeal. So I don't think this is going to get bounced.
Take some action on count 1 and count 3. For instance, either dismiss it or take some other action and remand down to the trial court for additional action. That would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different
strategy
trial that we would employ, and jeopardy will have attached, and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court
what's the
making its
briefing
decision,
schedule?
I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth
They must be exhausted.
is going. I believe that whoever it is that is appearing for the Commonwealth, for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday.
So the 24th.
And the reply brief would be to you 2 days hence. So the briefing.
I don't know what that
done
popping is in
relatively
court.
short
It's
order.
horrible.
The decision, that's another question.
So the
All right,
26th or
thank you very
27th.
much. Does it make sense for me to hear from Mr. Schillinger directly, or
So appellate counsel seems
or
to
do
be
you
in
want to
court.
handle this, Mr. Brennan?
So that's appellate counsel for the Commonwealth that's in court. Mr. Schillinger.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea
Schillinger.
how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday.
That's a
24th,
real
and then
fast
the
briefing
defendant's reply
schedule.
brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule.
Right, but then argument.
How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which at the same time, Commonwealth.
We have now started talking about the defense's appeal on the denial of the habeas petition. So we're talking about what's going on with the federal court. The Commonwealth, this is the Commonwealth, the attorney that's representing the Commonwealth at the appeal stage. So the appellate attorney is saying, look, it would be ideal to have all of the appeals done before we start trial, which starts April 1st. So we'll see. Both sides are like, it would be ideal to let this play out in the appellate court before we move forward with this trial. I don't know if that's going to happen, but both sides agree. But both sides have asked this court to continue the case before, and the court said no. So both sides agreeing doesn't mean a lot.
Well, is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information.
He did say the Commonwealth is strongly opposed to moving the trial, but it would be ideal
that would be helpful.
to have the appellate done.
We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that motion be filed today.
So they are filing a motion to stay.
Or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps
the
court
witnesses
is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right.
So it's indicated that the defense is also going to file a motion to stay with the court that heard the habeas petition. We have not gone through the habeas denial yet, but the weight of the arguments are going to be part of that. So the appellate attorney is like, hey, it would be ideal to have this done. The Commonwealth is opposed to continuing it. Getting that amount of jurors together takes time. Clearing a court schedule for a trial like this takes time. Getting all the witnesses together takes time. That said, the defendant has rights. And so if the best course of action is to let the appellate court play out, this defendant's out of custody. So the timeline on that is a bit more flexible. So the appellate attorney for the Commonwealth is like, I know the Commonwealth wants to go forward. However, the defense is also going to file a motion to stay, and the federal court can tell the state level court, stop right there. Thank you very much. You're not going to trial on this until the appellate issues are resolved, because the appellate issues are issues of double jeopardy. That's the main issue that they're arguing over. So again, if the appellate court rules in the middle of trial, it will cause a massive clusterfuck. I don't disagree with that. And with the defendant that's out of custody, a lot of courts would say better safe than sorry, because if you run through an entire 6-week trial and then the appellate court comes back and says, no, you can only go to trial on count 2, it overturns the conviction and then you go to trial again. If the court came back and said counts 1 and 3 are gone, you can't just let a verdict, if there is one, stand on a count 2. It would cause another retrial. So I understand. I reverse what I said. He makes a compelling argument. He makes a compelling argument for me. So he also gave the court a room to punt and said, we don't have to decide this today, but the federal court might put a stay on this.
I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
That's good news.
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best
He
estimate
can't be
would
held to
probably
that.
be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again,
So
I
6
alluded
weeks.
to all the recent publicity that I think is going to be very problematic in getting a jury. So
I don't disagree.
I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st.
I need to hear how she says something again, so I'm backing up.
Of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury.
Huh. Recent publicity that I think is problematic for impaneling a jury. The court may be more inclined to grant this motion to move this trial further away from the current publicity. That is interesting the way that she said it. She said her biggest concern with timing is impaneling a jury, and that recent publicity is a problem here. So that may be in consideration of the fact that the defense is going to file a stay. The defense is asking to continue. The Commonwealth appellate attorney said that it would be ideal to continue, even though the Commonwealth is opposed to a continuance, but it would be ideal. Well, I feel very differently about this than I did when the defense started talking. So this may actually get pushed a little bit.
So I'll let
Interesting.
both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic.
If we change the date.
I'll hear you all tomorrow on this then.
Oh,
May we address the court at sidebar on one issue before you leave the bench?
Sure.
Lyndon, I agree with you. I think the court is considering it. Yeah, I think so. And I saw some of you in the chat saying a jury may find Karen Reed not guilty. I agree. But for my calculus on what the way that the calculus is going to work out with this appeal is what happens if she is convicted while this appeal is pending. So that is not a statement of what I think the jury will do. That's how the calculus operates on trying to figure out whether or not that motion should be granted. I'm going to zoom past the white noise and the sidebar. But at the beginning of this, I'm like, oh, Emily, never say this is a placeholder motion for the defense. You said that about Baldwin's attorneys too. And then you kept going, oh, oh my. So the defense is formalizing their motion to continue. The appellate attorney makes some interesting points. And then the court's statement about recent publicity indicates to me that the court is not forestalled from potentially bumping back this trial. So when I said earlier that the court's not going to grant this, disregard entirely. I'm very interested to see where this goes when they talk about it tomorrow. So for those of you asking questions in the chat about things, I appreciate you asking questions because it always reminds me where I can be more clear in explaining my thought process, especially in the part that doesn't happen out loud. So I appreciate it entirely. So thank you. So let's see. I don't disagree. I don't disagree that the amount of recent publicity is the problem. Just the volume of it. I haven't seen all of it. I think the court, well, I would mean the amount of it, like how much it's in the public sphere and how much people are talking about it. It doesn't really matter what's being said. How much publicity is going on is a potential problem. And the fact that I have not seen the new series, though I've seen that there is a new series on social, but the fact that a new series, you guys were telling me it's a 3-part series on HBO or Max or whatever, dropped yesterday, is really recent to the trial starting. And they're not, once that's out there, the initial publicity is out there, but there's going to be publicity. Also, Proctor's hearings aren't done. He has, I think it's coming up this week, another part of his disciplinary hearing. Giving time for that to finish wouldn't be bad for everyone involved. Having some finality on that would help. But press is going to pick up ahead of a trial in this case, but we will see. It looks like they're ending. So I'm going to zoom more slowly, but normally you don't get into IA investigations until they are done. So it being done, I think, would be beneficial to everyone. Okay. All right.
All right. So we'll see everybody back here, not tomorrow, but Thursday morning at 9 o'clock.
Oh, we're
That'll
skipping
give
a
you
day.
time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay. So see you Thursday. All right. Thank you, everybody.
Okay, well, we were supposed to stream tomorrow. All right. Court is done for the day. There we go. I guess I'm going to get to Q&A. Court was supposed to be streaming tomorrow. Court's not streaming tomorrow. Does that mean I'm not streaming tomorrow? No, it means I'll probably cover something a bit shorter and then prepare for us to stream on Thursday as well. So, interesting things happening in court today. They went pretty quick today and ended up doing a half day. I thought they would do a full day. There's work she wants the lawyers to do. So there's work she needs the lawyers to do. We might go over that habeas denial tomorrow. I'll take a look. I'll ask the members what they want to do. But there's stuff we need to go over, and let's let court wrap up real quick. I am definitely, oh, okay, well, I guess court's wrapped. I guess court is done. Let's see. I cannot catch up on Baldoni Lively things tomorrow because there are so many filings that I have not gone through. I cannot cover it without it being like a 15-hour stream. So that's not going to be tomorrow. I will be catching up on those. There's so much happening. I will just have to reorient my brain because I was planning on this being today and tomorrow. So I'm very ADHD. It's going to take me a minute to reset and figure out what tomorrow is. We'll stream at 11 tomorrow. What we will be streaming is yet to be seen. I'm not going to decide now. I make no promises. I will want to eat and to think about it, and then we'll decide. There is so much going on. I'll just, again, figure out what we need to cover, and if we need to go through, I think I can probably summarize it, but if we need to go through the denial of the habeas, I'll take a look. So we will see. But it's going to take a minute. We can go over the ID episodes. Maybe. I'm keeping an open mind on tomorrow, but we'll stream tomorrow at 11. Let's try to go and summarize what happened today, and then let's get to questions, shall we? Shall we? I think we shall. I think we shall. We shall not talk about the blemishes on Emily's face. I know we have Koberger stuff to go over too. We have so much to go over. Let's try to summarize and then let's get to your questions. You guys had lots of really good questions, so I've saved as many of them as I can. We've got lots of super chats, so we'll summarize and then we'll get to questions. So let's swoop and summary. With about a half day in court for hearings on the Karen Reed case that mostly comprised the motions in limine, I was surprised at the end of the morning before the court took the break for the day that the defense has formalized a motion to continue the case and that the court has not dismissed it out of hand. We heard from the Commonwealth's appellate attorney. The defense asked that the court consider moving that April 1st trial date start back. No date was stated, but continuing the case to allow the defense's appeal to the First Circuit of the denial of the habeas regarding Karen Reed's right against double jeopardy against double jeopardy to be fully vetted out by the appellate courts before this trial starts. The appellate counsel for the Commonwealth said in court that there was an accelerated briefing schedule and that what would be ideal is to allow the appellate process at the First District or the First Circuit to complete or conclude before going forward with this trial, but it is the Commonwealth's position that they do not want to continue the trial. The court made an interesting note on the record saying that the court's biggest concern is the jury selection and impaneling a jury because of the amount of recent publicity, or at least that's what I took away from the court's statement. Let me see if I wrote down the court's statement about the recent publicity. I didn't use the exact word, but she said there would be a problem due to the recent publicity. And I wonder if the court would also like to push back jury selection and this trial to have a little bit more distance from quote unquote recent publicity. And yes, there will always be publicity, but the court has granted a essential gag order now. So you aren't going to have new interviews with the defense unless they are pre-existing. You're not going to have new statements. So the fact that a 3-part series is coming out on HBO Max or whatever this close to a trial starting could cause problems with jury empanelment. So getting a little further out in time may help, it may not. So it seems that the court is also concerned about how close this trial is to starting and is giving the attorneys an extra day to have some of those conversations. It seems to me that the court's at least considering whether or not pushing back the start of this trial is what's best for everyone. Because again, if the worst case scenario that's going to be going through the court's mind is you start this trial, it takes you weeks to impanel a jury because everybody's heard about this case recently and has thoughts, and then you have a jury trial completed. If there is a not guilty verdict, then it stops there. If there is a guilty verdict and then the Court of Appeals comes back and says that there is a double jeopardy issue, the result to that would be a new trial on just count 2, potentially. So then you've got the potential for yet another retrial depending on what's decided by the Court of Appeals. That's kind of the worst case scenario for the court is you have to do a third trial when allowing the Court of Appeals to decide would forestall that worst case scenario. Of course, the Court of Appeals could come back and say, no, we're not granting this appeal. No, this isn't an issue. Go forward with the trial on all 3 counts. But if they don't, and the trial has gone forward and there are convictions, the remedy to that is oftentimes go back and do it again on just count 2. And the court, I don't think wants that possibility looming out there, but we will see. So the court has asked the attorneys to essentially meet and confer about the appeal. The court has asked the attorneys to talk about the jury questionnaires. We still don't have a ruling on the motion to dismiss, and we are coming back to court on Thursday. They went through quite a few of the motions in limine that we saw ruled on during the first trial. I think the court's rulings will be fairly consistent. We also saw the lingering motions that had not been argued yet regarding the Commonwealth's neurosurgeon expert, and the defense arguing to limit the testimony of that expert not to the manner of death, but to the mechanism of injury, and in the alternative to have a voir dire. We know that there are going to be new experts in this case. We are seeing that new experts for the Commonwealth and the defense are going to be a thing in this trial. And we heard some estimates of how long this trial will take with the, and I'm looking at my notes, with the, where is it? With the Commonwealth saying that they need, I can say that more clearly. We've also seen the attorney's rough estimates for this trial, with the Commonwealth saying that with full court days, Monday through Friday, they would expect about 3.5 weeks for their case in chief, and the defense saying on the outside they would need 2 weeks for their defense. But of course, that's going to depend on how evidence comes in. It could be less than that. So we're looking at maybe a 6-week trial instead of a 10-week trial of evidence. And that, of course, doesn't include the amount of time it takes to pick a jury. Last time it took, I think, just about a week, like 5 days of jury selection. And there's been more publicity since. Jury selection might take longer. So we might also be looking at 2 weeks of jury selection, which will not be streamed. So will the court continue this trial? I don't know. And we didn't even get to the kind of the top of the day. The beginning of the day started with the court strongly admonishing the defense about statements made regarding the ARCCA experts. The court hadn't made a ruling on that yet. And at the beginning of the hearing today, the court found that the defense made deliberate and flagrant misrepresentations to the court at sidebar and in a written motion regarding payment to the ARCCA experts. The court then had a sidebar discussion with Karen Reed and her defense attorneys about what she was going to do with that. And at the end of the day, the court said, do not misrepresent things to the court, but did not sanction the defense, did not, in a monetary way, did not remove a defense attorney, and did not prohibit the ARCCA experts from testifying. The court made a very strong record and voiced their displeasure. It was very much I don't know, calling to the principal's office of the defense, and then ultimately denying the Commonwealth motion to forestall the ARCCA experts from testifying, and again reminding the defense that all of their discovery needs to be turned over. And I know the question's going to be, what about the Commonwealth's discovery? We're not on those motions yet because the court has not ruled on the motion to dismiss yet. And I'm curious to see what the court says about the evidence that the Commonwealth hasn't turned over to the defense. We also heard argument today regarding the motions to keep out any allegations or assertions or discussion of witness intimidation, and discussion about how that came in the first trial, where the Commonwealth did agree that that was not the appropriate topic area of questioning unless the defense opened the door for it. But the dramatic back and forth between the defense and prosecutor Brennan definitely showed that both of them are going to are going to push each other's buttons and aren't going to shy away from calling one another out in court. So that between the attorneys was not commented on by the court, but I was sitting there going, wow, we're all just bringing it up a notch, are we? And then at one point, Attorney Jackson said, I think we can just bring the drama down a little bit. I don't know if that's going to be possible in this case, but we will be back in court for this case on Thursday at 9 a.m. Eastern. Of course, I will be starting a bit after that. A, it's early. B, I like the Zoom room. C, we got to let our West Coast friends be awake for all of it. So we should get to questions Lawnards, it was a lot today. I'm going to go back through and I'll give you a better summary as we get into motions on Thursday about what's been ruled on and what's still outstanding. The big things that are outstanding really are the motion to dismiss. And now this question of a continuance, which I think is a possibility here. I think it's possible. That's going to be wild. But what are calendars anyway? We just live here. We just live here. Let's get to your questions, Lawnards. And Mel in the chat said, just waking up in Australia. See, we the far West Coast. We've gone all the way around. We've circumvented the globe and gotten over to Australia. Mel, it's good to see you. I know you're not the only Australian lawnard. I know we have lots of y'all, but yes, it keeps our lawnards on. Look, man, I don't want to stream court at 8 a.m. I really don't. I don't want to be in court at 8 a.m. I picked 11 a.m. as a stream time because I need a little room in the morning. Look, man, if it were 11 p.m. or 8 p.m., let's go. Am I an early morning girly? No, not at all. Not at all. Bailey, it's so good to see you in the chat, friend. I need to watch more of your videos to cover up the blemishes that have erupted across my face because my makeup is not great, but it is good to see you in the chat. This case, man, we will see if it gets continued or not. Bailey, wait, chat, you probably know. Has Bailey covered Corey Richens yet? Bailey, have you covered Corey Richens yet in Utah? Because I would love the conversation. She tried to get her attorney to sneak her in crushed white strips because she didn't like the way she looked on television because, the jailhouse coffee plus not being able to whiten your teeth. I know, chat, that you love Bailey. I know you do because, chat, we are the same. But this case, man, this case is busy. Next time I'm going to say we need to start, West Coast time for all our West Coast viewers, including Bailey. So Corey Richens, Utah, wild. But that trial's also supposed to start in May. I swear, if that judge does not allow us streaming even on delay, covering that case a day behind is going to be so frustrating. It's going to be so frustrating. But that trial starts in May too. May is always so busy. Y'all, May is busy. May is busy. May's gonna be busy. May is busy. We're going to do it, but May's busy. I was ready for this to start in April, but if it gets bumped, it gets bumped. And we'll bump. We'll figure it out. But the Koberger case is starting in August, and that's going to go to November. So we have a chunk of the year that's just like, that case isn't moving. I mean, Emily, never say never. Never say never. Cindy said, good morning. Excited to share that I found out I'm having a baby girl. 20 weeks. Turns out I'm built for pregnancy because no sickness or anything. Congratulations, Cindy. I am glad it is a smooth pregnancy. I hope it is a healthy and happy pregnancy and labor. And just congratulations. My pregnancies were miserable, but my children are delightful and I will take it. Audrey, good to see you. Get to turn in live on your birthday, turning 30. Happy to spend it with the Lawnards. Happy Dirty 30. I hope it is a blast. Have a lot of fun. If you enjoy a little bit of whiskey, a paper plane. Try a paper plane. They are so good. Beep boop 902 from hello from Scotland. Hello to you. I know our international law nerds are like, let's go. Marla Wolf said, I hope you had a great break. I had time off from streaming. Unfortunately, everyone traveling to my house and then getting sick changed it a bit, but we did get to spend some family time together. And my bathrooms have never been so clean as trying to keep members of the household from catching norovirus. So my house smelled like an urgent care with the amount I Lysoled it. But everybody is on the mend. We spent some quiet time at home. My carpets are very clean because they had to be. A house full of people with norovirus when you are the one not sick is It's just a delight. Everyone's been there. Look, it's been a minute since I've had to clean up after people who were that ill, but it's good. I'm going to stop there. Otherwise, I'm going to turn my own stomach talking about it. So it was time off of streaming that I would have needed to take because everybody was sick, but we got to spend some quiet time together. I got to do things for my parents to set up just like tech stuff that we had needed to go through and do. So we got to do that. My parents were on such an old email service that they need to move everything. So we got to spend some time doing the practical things of life that you need to do, like, hey, your email service is no longer going to be an email service, but it's like your Apple ID, so we need to move it, like all those types of things. So it was, we tried to treat it like a cruise ship. Trust me, I wouldn't let anyone touch anything. I was like, I'll bring you things, don't touch anything. It's a thing. Y'all know it. I don't need to tell you. I don't need to tell you that it's a thing. Y'all know what it's like. And it's been a minute. It's been a minute since I've had to clean up after anybody like that. So, DK Cripple said, did you get hit with weather? We did get some wonderful weather, but we did not have any damage. We did get some spicy windy weather, but not nearly as bad as others. I was watching and introduced my parents to Ryan Hall, y'all, because my parents live in Southern California where they do not get the spicy weather. So my parents did get all of the full spring experience here in Middle Tennessee. We had some days of just beautiful weather, and the trees are starting to bloom and the flowers are starting to bloom. The allergies are starting to bloom. And then we had growly, angry skies and lightning and rain and wind and trees down and all the rest of it, because the lightning is different in the South. It's not the same. It's got this whole like strobe disco situation. You get the bolts of lightning. It's a whole different vibe. The sky makes all kinds of noises. It's great. I love it. I didn't understand country music until I moved here. Not nearly. You listen to the thunder rolls, you move to the South and you're like, oh, hits different. I understand way better because the sky does all kinds of things. I love it. I love weather. I'm such a nerd. So I love watching Ryan Hall, y'all, because I'm such a nerd. But it was interesting because we had driven. I see all of you talking about. April P said, I hope I have everyone out in Missouri watching him. They should. I know Missouri got hit. We had gone to Missouri over fall break. And so as we get to explore more driving from Tennessee to other states, it's interesting knowing more places on the map. However, here's what I learned from Ryan Hall. First of all, in Arkansas, there is a town named So-So. I imagine that people showed up and they're like, how is it? And somebody was like, it's So-So. There is also a town in Middle Tennessee outside of Murfreesboro called Fudge Around. I have not yet find out, but Ryan Hall, y'all, is going through the map and I'm like, that town is called Fudge Around. They are on the map and it is literally called Fudge Around. It is literally called Fudge Around. So when I'm watching Ryan Hall, y'all, I'm just like, what? We need to find out. We need to find out. But Fudge Around seems to be in Coffee County, Tennessee. AR said there's a hot coffee in Mississippi. Look, man, I love it. And I appreciate the work that Ryan Hall, y'all, does. I really do. Sharon said this trial started right after I gave birth to my son, and now he's almost a year old. I watched the entire trial. I can't believe it's happening again. A, congratulations, and B, I can't, right? It's just, I can't believe we're doing it again. But a lot of you had asked, what happens if this trial is unresolved again? They can choose to try it again. The defense will make motions that they shouldn't retry it again, but they can choose to retry it again if it's unresolved again. Jess said, ready for the motions in lemonade. I mean, everybody's trying to make the lemonade. Reggie71 says, coffee and relaxing. I'm glad everyone was relaxing before I went live, because then we went to like DEFCON Red immediately. DEFCON Red. Mama Wolf said, my 5-year-old this morning, can we watch Emily today? I'm back. Hello, Mama Wolf and family. I am back. We are back today. I missed you guys. We needed more of a like downtime break. but life is what it is. Those are my lemons into lemonade over this break. Hazen and everyone who gifted memberships, thank you. I saw lots of new members in the chat. I will be I'm gonna see what we need to watch today, and I'll let you know what we're doing. I'll let you know. Tracy said, EDB missed you, got my Neuro Spicy hoodie. Love it. I love it. I saw lots of you talking about the y'all bot. Could you imagine the law version of the y'all bot? I love the y'all bot too. The amount of work that the y'all squad has done to bring fast, accurate, non-hysterical weather information is great. Sometimes it is hilarious, but the, prepared, not scared. I love it. I think they do a great job. I don't know what we would do with a law bot. Would we just have it do Black's Law Dictionary? The Black's Law Dictionary law bot. It would be like, law bot, explain motions in limine for us. I love it. But I like the cheekiness between Ryan Hall and the y'all bot. It's hilarious. They've really created something incredible and are mostly community supported like we are. I love that they've got a 501c3. I'll stop raving. Y'all who live where there's weather know. Y'all know. We could have it spew random case law. We just have to make sure it doesn't make up its own case law. Because that is an issue. We need to make sure it doesn't. Donna said, Brennan's candor to the court is perfectly fine. How many times has he misstated facts? I don't disagree. It's just not what was on the docket. I know I said it when we were talking about it earlier, but I said a lot of judges would have given an admonition to both sides. We'll see if it comes up in the motion to dismiss. We'll see if it does. ABC123 said, can you call it family time without a virus or bacteria trying to invade the household? I don't even know anymore. I really don't. Alex, this is the greatest emoji ever. I love it. Hello from Australia. Lots of you were here. LB said, just noticed my red gavel. It's been 2 years since Murdaugh. I loved every trial since. We have covered some trials. I mean, the cases we have covered, man, we have definitely, it's not going to slow down. I mean, we are seeing how fast stuff is ramping up in Idaho. And that might be what we need to talk about tomorrow because a lot is happening in Idaho as well. There is so much. Michelle asked a great question in the chat. If the judge were to fine an attorney who pays Karen Reed or the lawyers. When the lawyers get fined, that comes out of the lawyer's pocket. I've never been in that circumstance and I've not been a defense attorney. I can't imagine a circumstance where a defense attorney would turn around and charge their client. And if it is like a prosecutor, the prosecutor's office pays. Sometimes the attorney individually pays, but I don't really know how that would work. I'm going to ask some questions. Because when it's a private client, the attorney would pay for themselves. I don't think they would charge their client for that because it's not on their client. It is definitely not. So let's see. Hazen said, did she hold of sanctions? So does she have to address it? Did she hold off sanctions so she doesn't? I'm interpreting this as, did she hold off sanctions so she doesn't have to address it with the Commonwealth? I don't think so, because they are separate issues. They're separate issues. I think the written motion is really what did the defense in, is that in the written motion, it says that the experts weren't paid for by the defense when they were paid. So the court's not going to parse, well, what does paid for exactly mean? And we saw that. So I think that's part of the problem. So we will see. Kathy at Oz, happy 4-year anniversary for me. Happy 4-year anniversary for you. Kat said, Alessi is a thesaurus tucked inside of a trapper keeper. That is so delightful that we need right now as we walk back to class from the principal's office. Yes. Alessi is delightful to watch argue. I really do enjoy not only the style and manner of Alessi's argument, I enjoy the sprinkling in of the very law professory turn of phrase. It's giving personable appellate attorney, and I enjoy it. It is a nice balance on the defense team. I think the defense team needs that balance. You can't have all fire and brimstone it gets exhausting too. You can't have all snark. Brennan's snark is exhausting. So just like Lally's exceedingly long questions, Lally's 15-part questions were exhausting. You need to have balance. And I think Alessi brings really good and welcome balance to the defense team. So Liz said, I saw a discussion of a Bowden defense in another trial that showed the investigation was so messed up, guilt could not be found. Isn't that a sum of the whole Karen Reed trial? Liz, no, but that is the direction the defense has gone in. But the defense didn't go directly to the investigation is so messed up you can't have anything other than doubt, because they went third-party culprit. It would be interesting to see if they narrowed in on not third-party culprit, but this was such a woeful investigation that doubt abounds, but the defense can't argue both things well, and they went the avenue of third-party culprit. They may not this next trial. They may argue that this was a hopelessly compromised investigation, that Proctor determined it was Karen Reed from the jump and didn't investigate anything else, that those in the house weren't forthcoming, and that there were conflicts between the people at the house and law enforcement. They all knew each other, which kept law enforcement from being thorough in their investigation. I can see the defense going that avenue, saying, how can you trust what's going on in this investigation? Because it just simply doesn't make sense. They chose not to do that, but we might see them take that route this time. I think it's a stronger argument trying to argue that however many people were in the house are all on the same page is a hard argument for a lot of jurors to wrap their mind around, especially when you constrain it to what comes in evidence in a trial and the bounds of evidence and what can be argued. It's a lot to ask people to get on board with. I think it is a much easier ask of a jury to say, look at this investigator, look at everything he touched. How can you have anything but doubt? The Commonwealth does not answer the questions because they weren't looking for answers. They decided she did it, and that was it. The investigation stopped, and there's no curiosity, and then everyone knows each other. So there was no further curiosity or questioning. I think it's a cleaner way to go forward. I think for the Commonwealth, it's cleaner to focus on count 2. I think count 1 is a terrible overreach. So we'll see. Mama Bet said, I don't see the medical examiner on the Commonwealth's witness list. I grabbed this question because Mama Bet's, I wanted to take a look at that real quick. I have the Commonwealth's witness list, so we're going to pull that up once I find it, because this is their prospective witness list. Of course, this can be modified. We'll see if it is. It shouldn't be modified much, but it can be. But I'm going to pull this up and take a gander at that with us real quick. So thank you. Thank you for that note, because I think it's helpful to take a look at. But it's odd to not call the medical examiner. But let's take a look. I don't remember everyone that's on this witness list. I went over it very quickly. This was filed, March 14th, 15th? I'm going to go to the signature date. This was filed just a few days ago. March 12th. Wrong, Emily, wrong. Let's see. We've got civilian witnesses, which is who we would think that they would be. But I'm going to look for the medical witnesses. I know they added, the juveniles are still on there. We'll see if they call them. I don't know if that helps them very much. They added Aiden Kearney. I can't ever remember. I apologize, but they added Turtle Boy to the witness list, which will also be interesting with the sequestration order. They added Gretchen Voss to the witness list, which I think will probably happen, that they will bring that in. Canton PD witnesses, law enforcement witnesses. Let's see. No, Needham Police Department, Massachusetts State Police. Who would Dr. Bello work for? Forensic Lab, UC Davis Vet, State Police Crime Lab. Expert witnesses. let's see. We're looking for the doctors. Their chief medical examiner. So Dr. Scorty Bello is there on the list along with Renee Stonebridge. So it looks like all of the witnesses we saw last time medically. So there we are. Hopefully that helps. Chavion Smut said, I mean, maybe they were just trying to avoid a coroner armpits situation. I don't know if there's been wild things. That is going to constantly be on the list of one of the wildest things I've ever seen happen in real live court. Because if somebody put that in a TV show, I'd be like, that shit doesn't happen. And then we're in South Carolina and it's like, well, I just kind of, what? It will still blow my mind. Knit One Law 2 said it's Public Defender Day. I didn't know there was a Public Defender Day. It's Public Defender Day. Just wanted to shout out the thankless work public defenders do in protecting all of our constitutional rights. And there are great public defenders here on YouTube. If you do not know the public defenders here on YouTube, I'm sure there are more. But for our US-based public defenders, Natalie Lawyer Chick, can't recommend highly enough. To get a defense attorney perspective. And yes, there are lots of defense attorneys on the internet. She is a currently working public defender. I have no idea how she has time to still do the YouTube-y stuff. It's incredible to me that she does. And you guys all know Ian Runkle is also a public defender up in Canada. So we've got multiple, and I'm sure we have others around the internet that I am not aware of. So there they are. So lots of great attorneys here on YouTube. And I love hearing from all of them. Tripoli Bob said, was her motion to dismiss based on Brady violations denied? It wasn't ruled on yet. Is Andrea Burkhart a public defender? She's an appellate public defender. I think she still is a public defender. Andrea Burkhart gets squarely into appellate attorney in my mind, but I think she is a public defender doing appellate work. So I appreciate that, chat, because I did not mean to forget Andrea Burkhart. So Andrea is both. Perfect. Thank you, Lyndon. And thank you, chat, for reminding me. I appreciate that very, very much. Good morning, Kim. We're going to try to go through questions and then I'm going to go get something to eat because then we're going to stream tomorrow. Emily said, putting in an official plea to bring back coffee and cursey words mega mug because I dropped mine and it broke. Emily, I'm sorry to hear that. We are working with different distributors, but we have mugs in mind. Do not worry. We have mugs in mind. It is on our list for sure. Victor Mann asked, why does the Commonwealth always go last? The court was doing the motions in limine with the defense motions first. So because the court was doing defense motion first, the defense is making the motion and then the Commonwealth is opposing the motion, unless they're not. And they have not shifted to doing the Commonwealth motions yet. But we saw right at the end of the hearing where she gave the defense the option because there was a defense motion and a Commonwealth motion on different sides of the issue. And the defense deferred to letting the Commonwealth go first. So that's why the court started with the defense motion first. The defense's motions first. So whoever's bringing the motion goes first. They bear the burden. So hopefully that helps. Can you get a voice changer for him? I cannot voice changer Brennan. I cannot, just like I can't speed up Lally as much as we tried. And maybe that's what we need to do. We need to speed up. We need to speed up the attorneys at 1.25 and then maybe it'll be better, but then we lose some of the inflection. And sometimes it's the inflection that sticks out in my brain of like, wait, something's happening. So sometimes that's why I don't like being sped up. Christy said, I feel like the Commonwealth is too focused on disproving the defense theories instead of proving their case. Is that common? It is a common pitfall when you have really charismatic, I think, defense attorneys. I've seen attorneys fall into that trap most when the defense attorneys present their cases very well. Attorneys are a full scale of how they present in court and to a jury. And I think when the Commonwealth or any prosecutor gets caught in disproving the defense case, they've already lost. You have to run your own race, follow your own arrow, whatever sports analogy you want to come up with. Just pick an analogy. You got to ride your own dragon, folks. You do not get to go hopping up on somebody else's dragon. We're just forget the sports analogies. Back to fourth wing. Emily, stick with what you know. Yes. Archery, fourth wing. Forget the rest of the sports, but you have to try your own case as the prosecutor. Chasing down the rabbit holes of the defense's theories are not helpful. That's what your rebuttal case is for. Of course, there is room to address things proactively, but if your entire case is built on disproving them, then you're not proving your case. It is a pitfall. It is something attorneys have to be mindful of, and it takes experience to do that. And I think we'll see a very different case this time around. So, Lindsay said, depending on the book, you really shouldn't be hopping on someone else's dragon. Yes. Yes. Mildred looked up the chalks and said it came from chalkboard. That's what Chad had assumed. Mildred, thank you for fact checking for us. The law nerds are the best nerds. Christina also said, just because I'm a nerd, term chalks stems from the traditional use of chalkboards in courtrooms. Love it. Where attorneys and witnesses could use chalk to illustrate points in trial. I like the name. I like it too. I actually like chalkboards better, but I'm incredibly light sensitive and all of the various neurospicy things that I have going on. And chalkboards didn't hurt my eyes as much. Whiteboards that are reflective give me migraines. So I love it. And now a lot of courtrooms just have the smart boards. So there is that. Mega 96 said EDB. Question, and I think this is juror. Can a juror look up something while in the jury room, such as what does something mean, like a medical term or definition? Are they allowed to do any kind of research? No, they're not. And they don't have their phones. Generally, their phones are checked in with the bailiff who's in charge of the jury. They are not allowed to look anything up. Now, if someone on the jury is a doctor, they can explain more, but they are not allowed to do independent research. They're not allowed to go visit the scene. Like if they're driving home from court that night and they could drive past 34 Fairview, they're not supposed to drive past it to try to look at the way it's laid out. If they're not there on a jury view, they are not supposed to be there. They are supposed to rely on only what they are presented by the lawyers. If the lawyers fail to explain something well to the jury, that is on the lawyers. And yes, it's difficult to figure out what 12 people may or may not want to know, and when you are over explaining and when you are under explaining, but they cannot look things up. So I see some of you saying that sometimes on jury duty, you got to keep your phones. In California, they take the phones, but I can also imagine areas where they would just say, we trust you, don't use the phones. So I speak from what I know, and what I have seen is jurors having their phones taken to prevent. It's so easy to just be like, I ask my phone. Like it's such a part of our regular habit. If we don't understand something, to just look it up because we want to know. It's so ingrained in us. I think that a good way to prevent that, A, you're in a group, so it can be like, don't look it up. But B, I think taking the phones takes away that, I don't know, temptation or habit. I think a lot of time it's just habitual, right? Federal court, if you're going in to watch, takes away everything, including your phones. I had my glasses looked at. They're like, are those smart glasses? I'm like, no, they're not. they're just glasses. Felicity said the motion hearings are now a comfort watch. I don't know. I think you might be the only one feeling comforted. Carrie said watching EDB while waiting on test results for neurospicy genetic diagnosis similar to MS, hoping to get my mind off it by hanging with the law nerds. Carrie, you are in great company. The law nerds have overcome much and are an incredible source of support and humor and distraction. We're here for all of it. Music to my soul. I'm going to think about how I can share that with you guys. So let me think about it. Susan, thank you for the 5 gifted memberships, but I cannot put it up on the screen, but I will think about it. My hesitancy is that I do want to stream, and if we have copyright issues, it can prevent streaming. And so I want to be careful with that because I don't want to miss Thursday. Maria said the glass at the scene did not match the bar glass. That's my memory as well, is that the glass at the scene or the glass on the car was different. But I should say my memory is that one of those were not the same. And I was surprised by the result, but I don't remember the exact result. So Janice said part 1 was last night, part 2 is tonight, and then I guess part 3 will be the next night. Addison said, you've probably answered this somewhere, but can the prosecution interview the jury from the first trial, or does that count as asking about deliberation? It seems that in Massachusetts that is a no-fly zone. And so even when the jurors reached out, Lally put in a motion that he was not inquiring of the jurors. So in different jurisdictions, the rules are different, but speaking with the jurors after trial is not what is done in Massachusetts. So no, they can't. The jurors speaking publicly is what they are going to have to rely on. And if they're smart, they will. I'm sure Brennan is keeping his eyes on all of that. Blue Eyes Fairy says, I'm going to sprain my eyes rolling them so hard. I think a number of you felt that way. Brianna said, can this Rule 14 violation be mentioned by the Commonwealth in the trial in front of the jury? No. No, it can't. This is all pre-trial stuff that the jury's not going to know about. If there is, separate from this situation, if there is a discovery issue and the discovery issue is going to come up in front of the jury, there would be a motion for a jury instruction, and it would be a jury instruction that would be crafted and read by the court saying, that something hasn't been turned over and the jury is either allowed to make a negative inference for that, or if something's been destroyed, they're allowed to make a negative inference. So there can be motions for jury instructions. That's not going to be the solution here unless things don't get turned over. But the court's admonition of the defense counsel today, the jury will never know about. If things are not turned over and it harmed a party, then you can have motions and then you can have jury instructions. But it would be very spelled out, and the court would bring that in. So hopefully that answers that well. So I hope. All right, I'm going to keep jumping through your questions. Thank you for all the welcome back. I appreciate it. Cassie said, question, can they not hire new writers similar to them testifying, or she doesn't let them testify? I don't know what we mean by new writers. I grabbed this question because I wanted to answer it, and I am now blanking on what I was thinking. They can hire new experts, and that's fine. It just all has to be turned over. So that, if that helps. All right, let's see. Are the Commonwealth bringing in rebuttal witnesses for their own case? The Commonwealth's allowed to bring in rebuttal witnesses, and if they know the defense has an expert, they can bring an expert in that's technically rebuttal in their case in chief. They don't have to wait until a rebuttal case, and the timing on that's going to depend on the court. Carrie, thank you for the gifted memberships. Nishay asked, Emily, with federal court, they take all devices, including smartwatches, digital notebooks. Yes, they do. Paper, pen, unless you are approved media or an attorney in that court, typically for that case. Chronic Shocks Art Journal said, fun question. Did your ADHD ever make you stumble in court with words all the time? Like saying with the what's it? No. Or the thingy? Not necessarily, but there would be times that I would transpose words. I think that happens to anyone who talks quite a lot for a living. But I did have Judge Abby tell me last week that she was asking an attorney to cite her to where it said something, because the attorney was like, Your Honor, I think it's this way. And Judge Abby was like, I think it's this way, but can you show me where it says that it's that way? Because if you're saying it's that way, just show me. And the attorney was like, I don't know if I can show you, but vibes. And I died when Judge Abby called and was like, tell me the attorney did not look at you and go, vibes? She's like, no, they did. I was like, oh boy. I'm like, did you guys sort it out? did you guys sort it out at the end and figure out where it was? And she's like, we did sort it out at the end as we were having kind of a chat. I'm like, did you laugh? She's like, we all kind of laughed. And I'm like, I love that you all just kind of went, I know it's either this way or this way. And everybody was like, I know it's either this way or this way, but I don't know where it says that. There are some things that are so ingrained, you just can't find them. It's like, where does it say in the code section that a jury is supposed to be 12 or in different states 8 or 10 or whatever? And most people are like, I know it says it somewhere because like, that's the way that it is, but I don't know where to tell you. Vibes. We'll find it somewhere because vibes. I thought it was hilarious. Sam asked, will the jury know that this is a second trial? Not necessarily. They will know that there have been other proceedings, but the chances of somebody saying at the last trial as a witness is possible, but it should, when they bring up because they're inevitably going to bring up transcripts, it's going to be at a prior proceeding. And remember, some of these witnesses have testified at a state grand jury, at a federal grand jury, and at a trial. So there are at least 3 prior proceedings that there are transcripts from. So I think they're going to have to go with prior proceeding by date at a prior proceeding in 2024 or 2023, or more specifically by month and day. So it's going to take some time. It's going to take some time for that. Wend, thank you so much. I love the cat eye nails. I had the same color a few months back. I love it. I love it too. I broke one, so I need to go get the nailies done. I also have an event I'm going to, and they're getting grown out. So it's time, but it was green. It's March. It was time. It was time. I know, I'm so excited. I've never seen Metallica live. I can't believe I've never seen Metallica live. I've never seen Metallica live. We are done with court today. We are done with court today. All right. And I am getting through Q&A, and then we will be back streaming tomorrow at 11. Let's see. June said, question, Judge Cannone just made a comment about knowing about the documentary. Are they allowed to watch something on the case that they are on the bench for? I don't think there's any prohibition against it. Though my innate familiarity with the judicial rules of ethics is not as top of mind because it is not my job and has not been my job. So with a grain of salt, the judge is going to be aware of the media in the case, even if she's not following it closely, because it's going to come up in court and you kind of have to know what's going on. I don't know if the court will watch those things. I think they are allowed to watch those things. I think most judges would choose not to. But in this case, that is going to come up because the defendant is making statements. In a case where the defendant wasn't making statements, I think it's a little easier for the judge to be like, none of this is relevant to me. But the judges also are very good, or should be very good, at parsing out what's in court, what's out of court. The judge is going to be asked to rule on some of these things, but needs to wait for the attorneys to present them that. And Brennan brought it up in court multiple times today that was coming out. I don't think this court is unaware of what's going on publicly in this case, because even if you're not seeking it out, you know that things are coming out. So it would be really hard to ignore it. But I don't know if the court would choose to watch it until it's presented to her to make a decision on, because the court's going to have to make a decision on statements that are coming in, because the Commonwealth is going to bring in, I imagine, quite a lot of the out-of-court statements of the defendant. Maybe they won't, but I think that they will, based on all of it. Little Miss Red Velvet OG said, I am so shocked. Thank you for explaining all of this. That's what I'm here to do. From a UK perspective, I've never seen anything like this. Our legal system is A, very public, B, it can be quite complex, and C, it is, it's not always just straightforward. The court can be quite dramatic. Chicago. It's time to rewatch Chicago, either the musical, the movie made from the musical, but court can be very dramatic, whether or not there is a television audience, because when the lawyers are in court, there is always an audience, and that is the jury. So court can be wild. This case is particularly wild. This case has a lot going on. Like a lot going on. The attorneys must be exhausted. Pepe said, let Courthouse Becky be the presenter of Lawyer Traders. No. It would be fascinating to have Courthouse Becky on Lawyers Traders. Maybe we make it Court Traders because it would be fascinating. But I volunteer to host Court Traders. I volunteer to host traders, but with, court personalities and those who have been in trial, because I could see Dr. Curry being fascinating on traders. I can make a casting list in about 5 minutes. You, me, the law nerds. We're ready. All right. Let's see. We are still getting through all of the rest of it. Kat on the board said, Jackson really up here with, is it me? Am I the drama? That's for sure. Cat Lady Ballerina said, I used to work in the ER. There are estimates for how BAL changes. We would use it to calculate when someone would be sober, but would redo labs at the time to confirm the blood alcohol level was under 80. And it's a totally different use in a hospital setting versus in a legal setting. And that's part of the argument. It came in last trial. I think it'll probably come in again because it goes to the cross-examination and the jury gets to determine the weight. Though I don't know how much it's needed, but we'll see. Lovely said, can we please have a Law Nerds calendar? I am working on it. We are working on adding it into the app. It's been on our wish list. So it's one of those things that we are working on it. Little Miss Red Velvet said, I have a friend who went on UK Traders, Emily. It is unreal. I just saw that they're casting for Traders Canada. I have not yet watched because I am behind on literally everything. Some of the traders from other countries, but it's on my list because I love the show so much. And I loved watching Traders. I'm not going to spoil Traders, but I loved it. I love the concept of the show. I love how it's implemented. I enjoy it. I look forward to seeing Traders in some of the other countries that just do more like Big Brother and grab just people in. It's fascinating. I like the premise of the show. It's basically real life Among Us with a little bit of Clue. Nick said a continuation would mess up my project schedule. Same. Cassius, have you tried the Starbucks cherry chai? No. When did they come out with a new drink? I have been like in my house for a week. My parents left at the very end of the weekend. And so I have not much left my house. Maybe today, because I am starving. Laura said, I got my ACOTAR TOG tattoo on, I get my ACOTAR TOG tattoo the Sunday before Easter. So excited. Thank you for everything you do. Oh, Laura, I can't wait to hear about it. And we'll have to find a way for you to share it because I want to see it. Carly said, if they move Karen Reed, maybe you could cover Lori Vallow. Nope. She's defending herself. Could be entertaining shit show. I am not covering Vallow. Carly, I appreciate the ask. I have no desire to cover Lori Vallow. I do not cover cases with kid victims, especially when they go to trial. So sorry, chat. I know some of you are just like, yes, we want to see Vallow. So it is not one for me. I'm sure it will be covered. It is not one for me. Henhouse Bathco said, motion to not have trial while I'm in Switzerland. I mean, I grant the motion to have trial when it's most convenient for all of us. I am afraid that I will be overruled, but I grant your motion, Henhouse. David said, I'm from Cornwall. Also replay adulting is hard. Good to see the international law nerd crew. It's so good to see you. Golden Production says, think I missed it. Did they discuss the dog behavior expert coming in? They did. They did not discuss the defense motion to reconsider. Hopefully we'll get there Thursday. It seems like total fuckery. Are they no longer requiring MDs? what about ARCCA? I don't know. I don't know what they're doing. The defense has a motion to reconsider. If the court's going to let it go because the court made up a rule on their own and it's not the rule, it's just the court's rule, then ARCCA should be able to testify to it too. Look, I'm of the let the jury see more. Michelle M said, I'm late today, but did you see the UMG response to Drake? I heard about the UMG response. It's on my docket. It's on my docket. I heard it was sassy. I'm here for it. If it quacks like a duck said, came for the Karen Reed trial coverage, stayed for the missing juror side quest, that was perfection. It took us down an entire rabbit hole that was much needed, and I have no regrets. None at all. We need a top 10 of wild shit that's happened in court. We might, for sure. Let's see. Catastrophe said, can you be the judge for Rob's dog while Runkle defends? See, the thing is, I also have a conflict because there are times that I have represented Doggo as well. So I am unfortunately conflicted out. So, yeah. Amiss. I am also going to Metallica in May in Nashville. We will, law nerds, just scream at me if you see me in public. Just be like, Emily, and we will see you. It will go that way. Nem's girl said, I think the unknown glass is from the house. Since it didn't match any other glasses, someone could have thrown it. I don't know. I would need to, I want to go back to that testimony because my memory is not refreshed on that. But the defense can talk about the glasses don't match, but it's going to come up with Karen Reed making statements about it. It's going to come up. Whip it real good. Sorry. Okay. Discovery ID show and previous TV. Why is she still doing these shows? I don't know if they will help her, especially if she's saying new things. Why won't her lawyers stop that? I can only speculate. And I imagine that it is helpful to her in some way. And her lawyers are not stopping it because it is helpful to them in some way. I could speculate wildly about that, but I don't think that's helpful. They wouldn't stop it if it is beneficial. And again, if she really wants to do it, there's not much they can do to stop her. So she is allowed to make statements. She is allowed to make comments, and she knows that they can be used in court. And she is not in custody, and she has the ability and opportunity to do so, and there's interest. I can imagine from Karen Reed's perspective, and I think she said it in interviews, I want to be able to tell my story. So I think that's where we're at. So I imagine that there is benefit to having her side of the story out there without being cross-examined. So if they saw it as harmful, they would tell her to stop, and I imagine she would listen to her defense team. K-Silks asked, but she said, we're not paid for, have not been paid, or are not paid for. So isn't she talking past tense as they were not paid for at the time they testified? That's how I read it anyway. I think when taken in combination, what was said in the motion plus the sidebars, even leaving a misimpression about the defense experts, if they were saying we're not paid for at the time of trial, the motion would really clearly need to state at the time of trial, the ARCCA experts were not paid by the defense and were subsequently paid and then put in the date. I don't think Miss Little knew that when she filed the motion, but when you take it in combination with the sidebar, it is not the court's job to parse what is meant. It is the attorney's job to be clear. So I think there is room for more generous reading of what the defense said. The court has said this morning that they found that this was repeated. So the generosity does run out with most judges, not just this judge. So there is that. Kimberly said, Karen said in the documentary, this is my testimony. Well, there we go. There we go. Little Miss Red Velvet said, I knew we had a connection. Metallica, a former biker here. Love them. AC/DC, Deep Purple, would love to see them in Nashville. I think it's going to be fun. So look, it's concert season. I'm trying to stagger concert season around trial season and very active kids. It's just May is always busy. June is going to be busy. Next week is going to be busy. I have a last minute event with YouTube next week. So all of it's going to be busy. But for now, we have been streaming for 4 hours. I have the opportunity to get ahead for tomorrow's stream because we're not going to be in court tomorrow. We're going to be in court for Thursday. So I'm going to take that opportunity to, to go play Midas Merge. Let's be honest, there is an event going on for St. Patrick's Day, and I'm going to do that. I'm going to get some food. I'm going to prep for tomorrow and figure out what we're doing. Lawnards, if you are in the Lawnard Lounge, if you are members here on YouTube, I will be figuring out what I'm going to do with seeing what statements Karen Reed made, because now it has come into court, and letting you know my thoughts on that. So I will keep you posted. So Lawnards, thank you for being here. You are the best. If you are new here, you don't want to miss a moment in court. I know you don't. Get the Lawnard app so I can keep you in the loop. I should have mentioned it earlier, but we were chatting. It's been a minute. You guys are the best. I will see you tomorrow at 11 a.m. Central. I will see you back in court Thursday. Get the app. A, it lets me keep you in the loop. B, it is the way you know when I am going live, most assuredly, because you will not always be notified on YouTube. And it helps this amazing Lawnard community of ours grow. We built it for you, and we love it. So thank you for downloading the app. I appreciate you, Lawnards, and it gives me a way to always get in touch with you no matter what's going on. And that is important as we are coming up on a very, very busy trial season. So Lawnards, I will see you soon. Take care of yourselves. Hydrate, get some food. We'll be live tomorrow at 11 a.m. Central. See you then. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnard.